We are friends and foes. Friends outside the world, foes. Yes.
May I please, Your Lordship? Lordship, I'd like to mention item 20. The state is yet to 3 weeks to file our affidavit. Lordship.
Item 20.
Lordship, on the earlier question, the court has made an observation that this relate to some peculiarity that prior to her application, the appointment was given. So the court has given to make a proper instruction. And then several adjournment they are asking. So let it.
We're yet to receive any instructions, Your Lordship.
Now, what is your submission? What is your submission?
Lordship, let the matter be disposed at the earliest, Lordship, because
Heard Mr. S. Temjen, Learned Counsel for the petitioner, also heard Mr. M. Long Kumar, Learned Government Counsel, who prays for 3 weeks
Your
time for filing
Lordship.
affidavit in opposition.
Yes, sir.
The prayer is allowed. Prayer is allowed, list accordingly. We'll let them file the no observation, no other observation today. List accordingly.
Obliged, Your Lordship.
May I please, Lordship, Lordship, I beg to mention item 24. Lordship, here in this case, the court order 30/8/2022 was complied. So Lordship, I pray that the matter may be closed.
We need the file.
Lordship,
We'll pass orders when the matter is called. We'll close it.
May I please, my lord? My lord, allow me to make a mention of item number 17, Lordship. I've received the affidavit in opposition on behalf of the state respondents. My lord, 2 weeks may be granted to me to file my rejoinder, Lordship.
Heard Mr. Toshi O. Longkumar, Learned Counsel for the petitioner. Also heard Ms. Ina Holly, Learned Government Counsel. Learned Counsel for the petitioner submits that he has received the affidavit in opposition filed by the respondent, state respondent, and intends to file a reply to same and prays for 3 weeks, 2 weeks time for 3 weeks time for the same. The prayer is allowed. List accordingly.
Obliged, my lord.
May I please, Lordship. My lord, I beg to mention item number 14, my lord. My lord, if this matter may come up on 13th of May, my lord. My lord, here, the leading counsel, Sumita Gohen Borwa, she's from principal seat and she has some difficulties today. So if this can come up on 13th May.
Heard Mr. Takakichu, Learned Counsel for the petitioner. Also heard Mr. KV Angami, Learned Public Prosecutor. Learned Counsel for the petitioner prays for an adjournment on the ground that the conducting counsel for the petitioner is an outstation lawyer and she has some personal difficulties today. Considering the submissions made by Learned Counsel, the prayer is allowed. Let this matter be listed
On 13th May.
on 13th of May.
My lord, there is an interim.
The interim order shall continue till next date.
Much obliged.
May I please, my lord? Lordship, item number 25, Lordship. Lordship, and for respondent number 2, 3, and 4, Lordship.
Lordship, can you grant 4 weeks time to obtain necessary instruction? I've taken the consent of the
Heard Ms. Lucino, learned counsel for the petitioner. Also heard Mr. KV Angami appearing for respondent number 2, 3, and 4. Mr. Angami is also there,
Yes, for respondent number 1.
as well as Mr. N. Angami, learned senior government counsel. Learned counsel for respondent number 3, 2, 3, and 4. Press for some time for seeking
instruction.
obtaining instructions in this matter. The prayer is not objected to by the counsel for the petitioner, hence same is allowed.
Worship, I have some, Worship, all the parties are represented here. So, if your lordship may kindly peruse the order 14/10/2024. Notice is deemed complete, my lord, so, but it has been listed in the orders column
We
again.
fix it in admission column.
Yes, my lord, it should be in the admission column.
She has no objection, hence the prayer is allowed. As the service of notice on all the respondents has been complete, let this matter be listed after 3 weeks in,
After 4 weeks, Lordship.
after 4 weeks in admission column.
Pledge.
Lordship.
May it please your lordship. Lordship, I'd like to mention item number 16.
1/6.
Yes.
Your lordship, this matter at the moment cannot be taken up because the issue of whether the civil court, the district court can be able to entertain the appeal coming from the village as well as the Dabashi customary court. So, my lord, since that issue is yet to be decided by the zoning court.
It is pending.
In other matters, your lordship, this subject matter is pending. It's not yet decided, so this matter may be kept in abeyance.
It is
awaiting the-
pending in which case?
Your lordship, I forgot the name of the case,
Okay.
but
You have any submission? Heard Mr. Joshua Sheki, learned counsel for the petitioner.
your lordship, here I'm for the respondent.
Learned, what's your name?
Nongosa on behalf of Meadow Vero for the petitioner.
Learned, you repeat your name. Learned counsel for the petitioner. Learned counsel submitting on behalf of Mr. M. Vero, learned counsel for the petitioner. Also heard Mr. Joshua Sheki, learned counsel for the respondent. It is submitted at bar that one of the main issue involved in this case is whether an appeal from a decision
Of the village
of the
court as well
village
as the
court
Dabashi
as well
court.
as Dabashi would lie before the district
The
Ju-
district court, the
judge-
district judge, your lordship.
district judge or not is still under consideration before this court
My lord.
still under consideration before this court. Hence, this matter may be listed only after decision on the said only after decision in respect of the said issue by this court.
My lord.
The prayer is allowed, list accordingly.
Your lordship, my lord. My lord.
The registry will list it after.
Yes, your lordship, after that decision. Oblige, your lordship.
Please, Your Worship, I beg to mention item number 30 and 31 on behalf of Mr. Zedin Muli, the learned CDC. Hearing it again.
Heard Mr. What's your name?
Zed Kulun.
Zed Kulun,
On behalf of Mr. Zedin Muli.
submitting on behalf of Mr. Zed Anguli, learned Central Government Standing Council. Also heard Mr.
Manaksu, on behalf of Sir Aingin Nongja.
Give your name. Submitting on behalf of IMT Longchair, learned counsel for the petitioner. Learned counsel for the respondent submit praise for
A week's time. A week's time.
1 week time for what?
For listing the matter for hearing yours.
Seeks an adjournment for a week, which is not objected to by the counsel for the petitioner, hence same is allowed. List accordingly.
Pledge, Your Worship.
I appreciate your lordship. Lordship, I beg to mention item number 13. Lordship, this case is taken up in the Supreme Court today, Lordship. So for judicial propriety, this matter can be
This,
adjourned for today
this case is taken up.
in the Supreme Court today, Lordship.
Okay, same matter.
Yes, yes, Lordship.
Heard
Can you-
Mr. What is your name?
Peter Mere,
Peter
Mere,
Mere,
Lordship.
Peter Mere, learned counsel for the petitioner. Also heard S. Mary, learned public prosecutor. Learned counsel for the petitioner submits that a case pertaining to the matter involved in this case is listed before the apex court today,
Lordship.
and hence is praise
After 2 weeks, Your Lordship.
for
week, your lordship.
adjourning this case for today. Let this matter be listed after a week,
week.
after a week.
Lordship. Obliged, Your Lordship.
Lordship, I beg to make a mention for item 26. Your lordship, I seek for a week time to file an IA.
Heard Miss
Prezokira.
Krezokira, learned counsel for the petitioner, who prays for granting some time to the petitioner for filing an interlocutory application in respect of this contempt petition. The prayer is allowed. List this matter after a week.
That's the lordship. Lordship, I beg to mention item number 19, Lordship. Lordship, here I'm yet to file my affidavit in opposition, Lordship. So if Lordship may please to grant another 2 weeks time.
No objection, Your Honor.
Heard, what is your name?
Piro, sir.
Heard Mr. Write his name, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned government counsel, who seeks 2 weeks,
2 weeks time.
3 weeks time,
Since I'm yet to receive.
3 weeks time to file affidavit in opposition by the state respondents. The prayer is not objected to by the counsel for the petitioner, hence same is allowed. List accordingly.
The order is there.
Oh, the interim order shall continue till next time.
For motion from the supplementary cost list, item number 32.
Yes, lordship.
What is this?
Lordship, this is an application jointly filed by the applicant, the appellant, along with the claimant. Lordship. The claimant, that is Srimati Jamuna Devi, has proposed the the applicant number 1. The applicant number 2 has proposed to the applicant number 1 to settle the matter outside the court. And as such, the parties have entered into an agreement, settlement agreement. There is at page 9A, Lordship. Lordship, this IA is arising out of a make appeal, wherein the claimant has filed a claim petition before the tribunal for the death of her son, wherein the court has, the tribunal below has awarded the sum of rupees 20 lakhs. But Lordship, since due to some financial issues, the applicant number 2, that is the claimant number 1, has proposed and approached the insurance company to settle the matter. And as such, the insurance company and the claimant, they have come to a settlement agreement.
No. The claims tribunal has awarded this
Lordship,
disposed of the claim case.
Yes.
By awarding 20 lakhs.
Yes.
Now what has been
Now
settled?
the insurance company aggrieved by the
You preferred an appeal.
appeal. And during the time of pending of the appeal,
What is the settlement?
settlement is at Lordship at page 9, annexure A of the IA. Of the present IA. Lordship.
What is the settlement?
Settlement, Lordship. I may be allowed to read, Lordship. Settlement deed.
No. It has settled
Settlement is
at 15 lakhs.
Lordship. Yes, yes, 15 lakhs 10,000, Lordship.
Even though this is joint petition, I am representing the claimants here, Your Worship. And just on record that we have settled the matter outside the court, Your Worship, and as per the settlement agreement, I would pray that this matter will be disposed of, Your Worship. The next appeal, Your Worship.
We have jointly filed this IA to close the matter.
Settlement between respondent number 2. Who is the claimant?
I'm
Respondent 2.
two,
Vikram Arjel.
2, 3, and 4, Your Worship.
Who is number 1?
No, Lordship, at page 3, Lordship, come to page 3. Page 3 of the IA. This application is jointly filed by the claimant and the company. 1 is the company, the insurance company. 2, 3, and 4 is the claimant. 2 is representing 3 and 4.
3 and 4 are minor.
No, Lordship. 3 is the father of the deceased. 2 is the mother of the deceased. And 4 is the brother of the deceased.
Heard. Mr.
2 is, yes, Lord.
Forte, learned counsel for the, as well as Mr.
Zekul.
Z. No, heard Mr. Foseco Forte, learned counsel for the appellant / applicant. There are other IAs.
Lordship. This is for settlement, the settlement IA.
And other IAs.
IA 1, IA
Two.
10 and Lordship, IA 224 is for delay, condoning of delay.
Delay has not been
No,
condoned.
Lordship, not condoned. It's still pending.
Then
So in the pendency, the insurance company and the claimant, they have come to a settlement outside the court. So they want to settle this and close the matters. So they have jointly filed this
but when
application
the
to
main appeal has not yet been registered.
Lordship.
Appeal has not yet
No,
been
Lordship.
registered. How an order may be passed in IE? First appeal has to be registered.
Lordship. Appeal is registered, sir. Lordship. Lordship appeal is MSC Appeal 10 of 2024.
How appeal is registered when delay is not yet condoned?
Lordship, at the time of filing, numbers have been
But it is barred by limitation.
yes, barred by limitation. Lordship, if Lordship may, this is the Lordship, since the parties have entered into a settlement by this settlement agreement dated 10 March 2025, your Lordship may dispose of the IA.
When the main appeal is yet to be,
Dispose of the IA, praying for condonation,
yes, first
closing the IA.
that has to be done.
Both the IAs, one is for stay and one is for condoning. So Lordship can dispose of.
Thereafter only.
Thereafter, Lordship can pass an order in the main appeal also.
Okay.
Lordship can, Lordship, since this is beneficial legislation, Lordship can
Second I is for two
for
is for
staying the
that you are not pressing.
Lordship, no, who am not pressing that for staying. So
Let us first take this I for condoning the delay.
Lordship.
You're appearing for all the respondents in.
Yes, Your Lordship.
Heard Mr. Foseco Forte, learned counsel for the applicant in IA number
54.
224/2024. Also heard Mr. Z. Kulnu, learned counsel for the claimants slash opposite parties. This interlocutory application has been filed under Section 5 of the Limitation Act 1963 by the applicant slash insurance company, praying for condoning the delay of 38 days in preferring the connected MSc appeal, whereby the applicant has impugned the judgment and award dated 8/8/2024 passed by the Motor Accident Claims Tribunal, Nagaland, Dimapur, Nagaland, in MSc case number 85/2023. Since the learned counsel for the claimant respondent has appeared and has not objected to the condonation of delay, not objected to the prayer for condoning the delay in preferring the connected MAC appeal, and since the grounds mentioned by the applicant for preferring the connected MAC appeal beyond the period of limitation, appears to be sufficient and good grounds, the prayer for condoning the delay in referring the connected MAC appeal is hereby allowed. And the delay of 38 days in filing the connected MAC appeal is hereby condoned, and this interlocutory application is accordingly disposed of.
Lordship.
Then I number 226, the heard Mr. Foseco Forte, learned counsel for the applicant slash insurance company, learned counsel for the who submits, also heard Mr. Z. Kulnu, learned counsel for the claimant respondent. It is submitted at bar that since the learned counsel for the applicant, Mr. Foseco Forte, permits that since there has been an amicable settlement between the parties, hence the applicant insurance company is not pressing this interlocutory application.
Lordship.
And you withdraw it
Lordship, I'll withdraw it.
and allow praise for allowing the applicant to withdraw the same. The prayer is allowed. This interlocutory application is dismissed on withdrawal.
Lordship.
Now come to I number 27.
Lordship, settlement agreement is at page 9.
This
Settlement deed.
heard Mr. Foseco Forte, learned counsel for the applicant slash appellant in MSc appeal number 10/2023. Also heard Mr. Z. Kulnu, learned counsel for the claimants respondents. Stop. This joint application under Order 23, Rule 3 of the Code of Civil Procedure 1908 has been filed by the insurance company as well as the claimants, praying for praying for disposing of the connected appeal, that is MSC appeal number 10/2010 24, on the basis of the amicable settlement arrived at between the parties. It is submitted at bar that the appellant, that the claimant that the insurance company, where is the, that the insurance company, that the appellant in MEC appeal number 10/2024, namely New India Insurance Company, as well as the claimant number 2, on behalf of all the other claimants, have executed a deed of settlement whereby it was agreed, it was amicably agreed between the parties that the insurance company shall pay a sum of rupees 15,10,000 only as full and final settlement of the compensation to be payable full and final settlement of the claim of the claimants opposite parties. You will withdraw, or it will be disposed of in terms of the settlement.
Lordship dispose of this appeal in terms of the settlement.
It is also submitted by the learned counsel for both the parties that the MAC appeal number 10/2024 may accordingly be disposed of in terms of the settlement arrived at between the parties by way of between the parties within. Stop. Considering the submissions made by learned counsel for the insurance company as well as the claimants, as well as considering and after going through the settlement deed annexed as annexure number A to the joint application under Order 23 Rule 3 of the Code of Criminal Procedure. This court dispose of the interlocutory application that this instant interlocutory application with an observation that the connected MSC appeal may be disposed of in terms of the settlement arrived at between the parties by the deed of settlement executed between them on 10th of March 2025. This interlocutory application is accordingly disposed of. In MSC appeal number 10 of 2025, heard Mr. Jose Forte, learned counsel for the appellant, also heard Ms. Z. Kulnu, learned counsel for respondent claimant. In view of the order passed today, that is on 21/3/2025, in IA within bracket C number 27/2025 2025. This appeal is disposed of in terms of the deed of settlement
Dated 10 March.
executed between the insurance company and the claimant on 10th of March 2025 and annexed in the interlocutory application as Annexure A. Be
Yes, Lordship.
disposed of.
Lordship. Highly obliged, my lord.
Pleasure, Lordship.
For motion from the supplementary cost list, item number 33.
Yes, Your Lordship. Your Lordship, the present application is for implement of the Commissioner and Secretary, Personal and Administrative Reforms Department, Nagaland, as respondent number 5. As respondent number 5, Your Lordship.
What we will do? What is to be done?
My lord.
Yes,
My lord, I'm appealing for response number 3 and I filed affidavit. My lord.
no, in this IA, whether notice has to go.
Yes, my lord.
This heard Miss, what is her name?
Kiprisenyo.
What is her name, Miss?
Miss Kiprisenyo.
Learned counsel for the petitioner. This application, this interlocutory application has been filed by the petitioner of in connection with civil original in connection with COP within bracket civil number 33/2024, praying for impleadment of Shri Muhammad Ali Shihab, IAS, Commissioner and Secretary, Personnel and Administrative Reforms, Department of Reforms Department, as respondent number 5 in civil original petition, as the earlier incumbent, as the earlier Commissioner and Secretary, Personnel and Administrative Reforms Department has been transferred. We allow this interlocutory application.
No objection, my lord.
Is submitted by learned counsel for the applicant that the applicant has filed a civil original petition within bracket contempt number 33/2024, wherein willful non-disobedience of this court's order dated 27/6/2024 in WPC 80/2023 has been alleged. However, during the pendency of the said contempt petition, the respondent number 2 in the say, who was the earlier,
Anup Kinchi, yes, my lord.
he was as shown as respondent number
2, my lord.
2 has already been transferred, and Shri Muhammad Ali Shihab has been posted as new Commissioner and Secretary, Personnel and Administrative Reforms. And in view of the same, it has become necessary to implead him in the said contempt or in the said civil original contempt petition. Considering the submissions made by the learned counsel for the petitioner, this interlocutory application is allowed. Let the name of Shri Muhammad Ali Sihab, IAS, Commissioner and Secretary, Personnel and Administrative Reform Department, Kohima, be impleaded as respondent number 5 in COP number 33/2024. This interlocutory application is accordingly disposed of. In IA number, you have to file a new
Amended petition, my lord.
amended cause title.
Yes, my lord.
Heard Miss Kekrisino,
Yes, ma'am.
learned counsel for the petitioner, also heard Mr. T.E. Iba Form, learned counsel for learned government advocate appearing for respondent number
3.
3. In view of the orders passed today in IAC number 29/2025, whereby a new respondent number 5 has been impleaded, the petitioner is directed to submit an amended cause title in this case within a week from within 1 week,
Within a week, your lord.
within a week from today, list accordingly.
My lord, I may be allowed to serve notice to the newly impleaded respondent through registered AD.
Okay, okay. The petitioner shall also take steps for issuance of notice on newly impleaded respondent
Through registered AD.
by registered AD as well as by legal mode within 3 days, within 3 days from the date of this order, returnable after 4 weeks.
Yes, ma'am. Oblige, my lord.
Much obliged.
For admission, item number 1 to 12.
May it please, my lord. Lordship, all the writ petitions are analogous, lordship. It's all
How
the,
many writ petitions are there?
writ petition
4.
188 to 199. 199.
This is item number 1.
88, starting from 188 to 199, and the first one 208. That will amount to 188. 12, lordship. If my lord will kindly
12.
bear with me, I will go by 188. The first one is filed later on, subsequent to all this. Inadvertently, the respondent was left out. That's why the first one listed today is for the subject of philosophy, and this was filed subsequently. So in the first batch of writ petitions, so I will rely my case on 188. It's all the same logic. Here there is nothing.
188, that is item number 2.
Yes, yes. That was the first batch that we filed. So all the documents are included here, mostly.
What is the matter?
This is lordship appointment of assistant professor through backdoor. That is class 1 gazetted lordship. Lordship, I will just rely my case on issue of law only. I'm not going to any other issue of law only whether there was a advertisement at the time of appointment. That's all. That will only be my case, Lordship. Nothing more, nothing less. Now,
Please, your lordship.
Yes.
Before my learned friend proceed a little further, there is a convoy of cases listed today along with the first item, because there are series of cases.
This is the second item,
Yes,
item number 2.
yes, and the councils are also similarly, a convoy of councils are involved in this particular case.
Yes.
On 4/4/2024, this honorable court passed an order directing the UGC to be embedded as a party respondent.
UGC.
Yes,
Okay.
University Grants Commission. That
Okay.
is also, they have also not come forward.
uh,
To that extent. that-
just
that they are
an
completed.
intervention, Lordship.
Secondly, my learned friend is fully prepared, so before she could fire all the entire bullet, I would just like to point out one important aspect, that is during the pendency of the writ petition on 18th of December 2024, the respondents whom I'm representing, they were all absorbed in the service.
Okay.
So a fresh course of action has been arisen in view of absorption of the petitioners, because the prayer made in the writ petition is the post should be advertised. That was the sole plea. So in order to do that, against which post should be advertised, which should not be advertised, that is also not very clear. But so far as the petitioners are concerned, we are already absorbed on 18th of December. And we have filed a caveat also that in the event of challenging that absorption order, then we should be given an opportunity of being heard. So
That absorption
fresh
order has
course of
not been
action.
challenged.
a fresh course of action has already been arisen. So if the petitioner is aggrieved by such absorption, then they can file a fresh writ petition challenging the absorption. Otherwise, this writ petition has become infructuous in view of the subsequent development, lordship. So it may not be necessary to go into further detailed hearing of the case in view of absorption of most of the respondents in the series of cases. So far as I'm concerned, I will furnish a list that against which cases I'm appearing, and I'm not representing the entire respondents also. But then the number of cases.
Now, who are the writ petitioners? How they are involved?
We are net qualified petitioners. Lordship, here we have to differentiate that. I pray this judicious court will take notice that whatever the learned senior counsel has submitted before this honorable court, subsequent order, we are not on that. And they illegally having absorbed does not legalize
No,
their appointment order.
But you are not challenging the regularization orders.
The regularization order, Lordship, that is another absorption or regularization is all the same. They have taken the name absorption because the honorable court in the interim order directed the respondent not to regularize the service of the petitioners. That's why, in order to avoid the word regularization, it's absorbed.
That is
Absorption depends.
absolutely incorrect, lordship, because so far as the petitioners are concerned, I have furnished a list of the cases where I'm appearing, and the
No.
number of respondents whom I'm representing.
Lordship,
I
let's be.
can furnish the orders, lordship. These are all orders after I entered appearance. and from the motion, on the day of motion, no interim order.
Lordship,
Thereafter,
in another,
a subsequent order on 13/11/2023. From that day onwards, the entire cases were clubbed together and listed together. In some cases,
Who are the other councils?
other councils are there. There are many, but
for some of theirs. Same case would be exponential.
Lordship.
so far
I'll
as,
come to you.
so far as the list which I have furnished, so far as those cases are concerned, these are all orders passed by the Honorable Court, and there is no interim order in these cases. Therefore, in cases where there are interim order restricting the government not to regularize or absorb, those are different things. Those cases may be
No.
listed separately,
no.
because my learned friend may have a grievance on that, in spite of the interim order, why they are doing it. That is what my learned friend has submitted just now.
Lordship,
Now, so far as the cases where I'm appearing, in those cases,
There is
there
no
is
interim.
not even a single interim order. Therefore, there is a fresh course of action on 18th of December 2024, and they have not challenged. We have filed a caveat also.
Lordship. Here we have to be specific.
Infractions.
It's not infractions. How can their illegal appointment, backdoor appointment become infractions? We are challenging whether there is advertisement. So the subsequent action, that is another, as my lord is.
No, but unless you challenge their regularization.
Lordship, here is, I humbly submit one
What
aspect.
what I understand, out of 12 numbers of writ petitions, in 8 writ petitions as submitted by learned senior counsel, there is no interim stay. Therefore,
Lordship,
in at least in those 8 writ petitions, a fresh cause of action has arisen. And unless you challenge that,
Lordship, just my humble submission before this honorable court. That is a subsequent action when, and this case has been, this case has been proceeded since 2015. It's a long, if my lord will peruse the writ appeal, it is already covered case, Lordship. My lord will kindly appreciate. This writ petition challenging the appointment order, the very appointment order which they were appointed through backdoor. We have challenged it. Their absorption or regularization doesn't legalize this. And one aspect, Lordship, I will satisfy my Lordship. One aspect is that if this writ petitions goes as per the law is very clear. If these writ petitions are dismissed, the whole case collapses. So subsequent action, what the government has done, and this is done, forget about the with or without interim order. I'm not concerned here about the interim order also. So they don't have an interim order. Interim order in a backdoor appointment, Lordship, with or without interim order. When the appointment is void ab initio from the beginning, we are only on the appointment order. Subsequent action, they have violated. There is a writ appeal I have annexed in my annexure. So, Lordship, if their appointment goes, the whole case collapses. So my lord will have to be very specific about this, Lordship. Subsequent action, they are trying to take advantage of that. But that is illegal order. Whatever absorption, whatever regularization.
if it is illegal, it has to be challenged.
That is another issue that will come later on.
Because if you don't challenge, it will remain.
Writ petition has been filed challenging our contract appointment.
And moreover,
And
this batch of writ petitions, if in 4 of the cases there is an interim order that
No.
has to be segregated.
Interim order is in another writ petition, that is, and when I prayed for interim order in this, Lordship,
In these 12 cases, there is no interim order.
no interim. And when I,
Then
Lordship, is it?
you have to challenge. their absorption.
Lordship, in one writ petition, that is, writ petition 140, in 340, that is 340, that is filed against those who it was segregated. It was segregated, and that was filed against those who does not possess requisite qualification.
Okay.
So there, interim order was granted.
But
When
that is-
this
that
batch
is-
came up,
That is not before
yes,
today.
yes. So when this matter came up, I say that in other writ petition, interim has been granted. Then this honorable court stated that since same cause of action in the previous one, since interim has been granted, it doesn't, since it covers the rest, it need not be mentioned. That is what this honorable court said, and that is in the open court, Lordship.
No, but
So-
there is no interim.
There is no interim. So in an appointment, backdoor appointment, Lordship, in an backdoor appointment that was made in violation of Article 1416, Lordship,
Now,
Be
now,
it-
now what do you propose?
I propose that this
To
honorable
go
court.
ahead with the hearing
Yes, Lordship.
or to either amend your petition or to file a new writ petition in view of this the batch of writ petition becoming infructuous.
Lordship, I will say that with humble prayer before this honorable court, it has not become infructuous.
Okay, we
They
may-
getting
We may hear
absorbed.
on that ground whether it has become infructuous or not. And
They getting absorbed doesn't regularize their service, Lordship. When the very appointment is void in the
all
beginning.
fairness, I would like to submit in this way, Lordship. In the writ petition, what was challenged? Our contract appointment was challenged.
Of course,
So that
now
is
you
the
are
result.
Not-
no longer
our contract.
contractual.
I'm absorbed already. So if any order is
They are
to be
no longer
passed
contractual.
as sought by the petitioner in the writ petition, what will be the consequences? That is the reason why, in all fairness, I'm making a submission that this has become infructuous, and if they are agreed.
what about the
Cause of action
government?
has already been arisen, so let them challenge that. Otherwise, in this present writ petition, what is there to be considered?
Ms. Zimomi,
We are no
you
longer
think
contractual.
over it
We are already absorbed.
and make your submission. We may not take it up today. You come up with your submission in view of the submissions made by Learned Senior Counsel that your writ petition has become infructuous. You want to proceed with the hearing?
Lordship,
In view of the submissions made by Learned Senior Counsels that as more,
then.
whether all of them or most of them. Most of the writ petitioners are, almost all of the.
I haven't seen yet, Lordship.
You have filed the
File
absorptions,
caveat also.
and in this case, you have filed their appointment orders.
They have enclosed appointment orders, which was on contract appointment.
And after absorption,
And up to the absorption, no.
you filed that on record. Let that be
Give
on.
us, Lordship, in that matter, if my lord is saying that, I mean, the learned counsel is
No,
submitting before
he-
this honorable court that the cases have become infructuous. Here arises the question of law, Lordship, why when the cases are subjudiced before this honorable court, under what circumstances, under what
No,
authority?
when there is no stay, there is no bar. Suppose, had there been a stay, question would have been different. But in this case, as there is no stay, the,
Lordship, in that matter, I will clarify. Kindly give us 1 week.
okay, you also bring on record
Yes.
their absorptions order. Heard, Mr.
Let it be after 15th
No, Lordship,
of April, Lordship.
let it come up
Because
after Lordship.
we need time. Yes.
Let that be on
They are
record.
posted elsewhere, all over the state.
Lordship,
They are
let,
scattered all over the state.
no, Lordship,
Heard Miss Z Zimomi.
then 10 days.
10 days and 15 days are not. You are for all the petitioners.
I am for the petitioners.
Heard Miss Z Zimomi.
10 days, Lordship.
Oh. This is from item number 1 to item number 12. Item number 12. Heard Miss Z Zimomi for the writ petitioners in all the writ petitions. Also heard Mr. C.T. Zamir, learned senior counsel assisted by Mr.
I am Chen.
I. M. Chen, learned counsel for respondents. Amita, यहाँ से ले लेना. Respondent
10 days.
in WPC number, respondent number 6, 8, 9, 10, 12, 13 in WPC number 189/23. Respondent number 5, 8, 10 in WPC number 190/23. Respondent number 7, 8, 9, 10, 11, 12, 14 in WPC 191/23. Respondent number 8 in WPC number 192/23. Respondent number 5, 6, 7, 8, 11, 12, 13, 11, 12, 14, 15, 16 in WPC 194/23. Respondent number 7, 11, 12, 14, 15, 17, 18 in WPC 196/23. Respondent number 5, 6 in WPC 197/23. And respondent number 5, 7, 5, 8, 9, 11 and 15 in WPC number 198/23. Also Mr. R. Iralu, L. Iralu from that list. Also had Ms. V. Sukre, learned additional AG, appearing for the state respondent. It has been pointed out by, it has been submitted by learned senior counsel for the respondents that during the pendency of these writ petitions, almost all of the writ petition, all of the respondents, private respondents have been absorbed in which posts? Different posts.
Assistant professor.
In the post of assistant registrar, assistant professor. And hence, he submits that since the challenge in these writ petitions was against their appointment in contractual post, the writ petitions have become infructuous. On this, Ms. V. Zumomi,
Objective, Lordship.
learned counsel for the petitioner, submits that she may be granted
10 days.
10 days time to
I
make
haven't received the
to-
appoint.
to make submissions on law point regarding the point raised by learned senior
Lordship.
counsel. So considering the submissions made by learned counsel for the respondent side, you are praying for filing additional affidavit.
Yes, Lordship.
Learned,
At least a month's time will be required.
No, Lordship.
learned,
Let the matter come up on.
learned counsel for the respondents also prayed for time for filing additional affidavits by the private respondent to bring on record the absorption orders, their absorption orders in the, as assistant professors. Considering the submissions made by learned counsel, when we can.
On
fix-
first,
After
Lordship,
15th
first,
At least a
Lord-
month's time.
no, Lordship.
Just the compiling and submitting will.
Let the matter come up on first.
How much time?
Require 4 weeks, please.
After
No,
15th
Lordship.
April, Lordship,
No, Lordship.
middle of next month.
File an affidavit again in all the petitions, we will be filing separate affidavits.
Correct, Lord.
Lordship, let the matter kindly come up on 1st of April. I have so 10 days for clarification on the point of law. So let the matter come up
Since
and
we are
let
filing
let the
the
matter
affidavit,
let
No,
them
why
come up.
piecemeal?
No,
Let it be
she
in
may,
one go.
If I am going to challenge, they may not. I will receive the
no, let it
appointment.
come on 1st of April.
Yes, Lordship.
She may agree that her case has become infructuous.
Yes, that's all.
She may agree to your submission on that day.
I will have to see the
I
point
will
of
give
law.
one 4 weeks time to you. And on the point for making submission by learned counsel for the petitioner, it will be listed on 1st of. The respondents are given 4 weeks time to file affidavit,
Yes.
additional affidavit as sought for by them. However, let this matter be listed on 1st of April so that learned counsel for the petitioner may make submissions
Lordship,
as.
here, one aspect is that it might cause some discrepancies. If we are to challenge the subsequent absorption order, regularization order. It is up to the petitioners whether to challenge or not. So they may not file affidavit, just that I need to have the absorption orders. Otherwise, they need not take that much time to file they need not file affidavit
No,
because
You
they-
make your submissions on 1st, whether on their plea that your case has become infructuous. And
so
he-
without Lordship, for that matter,
let it be on 1st, let it be on 1st.
let it be on first and
If the case survives beyond 1st, then you will be filing your affidavit.
yes, that's all, Lordship.
Otherwise, it will be disposed of on 1st. If she-
Lordship,
If my
that
learned
is,
friend is to make a submission and a question of law, then why not next week? Even on Monday, can we list it? Even today also, my learned.
No,
friend can
she's
submit.
seeking, seeking,
On the
10
point of law only.
no, she's seeking 10 days time.
I want to
preparation.
procure the appointment absorption orders from my clients because they have,
Yes, she'll be quite time. Even for
No,
us,
no,
quite
no.
time.
so,
That
but
is
why it
we are
is so
making a
hard to be
submission that
listed
let it be
on
fixed on
first?
15th of April or any date.
Why
after 16th of
every
April.
backdoor appointment
that
cases
time?
are being fixed
Why not
beyond
time?
15, Lordship?
Yes.
First,
First.
let it be on 1st, and I have already dictated order.
Lordship.
But I believe the last dictation has not been concluded. Lordship was about to conclude the dictation and then my learned friend has
No.
interfered with. I was not very clear on the
Let the
last.
matter come up on first.
Amita, read it. You are given 1 week, 4 weeks time to file.
That is clear, but
She
on
will,
the point where she was supposed to make submission, Lordship was dictating and then my learned friend
it
has
is fixed
interfered.
on 1st.
No, no.
Look.
Fixing the date is one thing, but on what point she has to submit, Lordship was dictating, but my learned friend has interrupted.
Read it.
The respondents are given 4 weeks time to file additional affidavit as sought for them. However, let this matter be listed on 4th of April 2025 so that the learned counsel for the petitioner can make submissions.
May make submission as regards the plea raised by learned counsel for the respondents of this batch of writ petition having become infructuous.
Blush, Lordship.
For admission, item number 15.
give this one to Steno.
Lordship, we'll be filing our affidavit in reply today, so if this matter can be listed for hearing.
They will be filing any submission.
No, Your Lordship, since they will be filing my reply to my counter, my lord.
Heard Ms.
R. Mary, Lordship.
R. Mere, learned counsel for the petitioner, also heard Mr. N. Angami, learned senior government counsel. Learned counsel for the petitioner submits that the writ petitioners would be filing their reply to the affidavit in opposition filed by the respondents. And this matter may be fixed for hearing.
Lordship.
The prayer is allowed. Let this matter be listed for hearing.
In the,
Af-
in the usual course, Your Lordship, the hearing list, after 2 weeks, Your Lordship.
After 4 weeks.
Lordship.
In the meanwhile, the petitioner may file their reply to the
Lordship.
affidavit filed by the respondent side.
Lordship. Deeply obliged.
For admission, item number 18.
Please, Lordship. My lord, this is a very short matter. It's ready for hearing. My lord, the petitioner herein is challenging the joint court decision dated 21/2/2021,
What are you challenging?
challenging the joint court decision.
No, I'm not getting it.
Joint court decision. Joint court decision, in a sense, the two village, they had a joint sitting and they have decided to have a joint court. And on that day, a matter was decided.
Joint
Yes.
court decision.
Yes, my lord. I'm challenging that on the ground that this is not a recognized court as per the rules for administration of justice and police in Nagaland 1937 rules.
Just a minute.
My lord, before coming to the annexures, I'll just sum up the short facts.
Yes.
The petitioner herein is the owner of the land, known as Tita Chom, or also known as Chita Chum. And he bought, this land is measuring around 3,85,000 square feet in the year 2010. He bought this in the year 2010. And he has been cultivating this land between 2010 to 2012. Till then, there was no objections or no issues on the said land. But when this two-lane road construction came, the private respondents, they started claiming ownership over the land. And that is how the two village council, that is the Lozami.
Who is appearing for private respondent?
My lord, private respondents notice are completed on private respondents.
They have not appeared.
Yes, they are not appearing. For private respondent number 5, 7, 8, 9, 10, and 11, order has been passed on 4/10/2024. 4/10/2024. And for private respondent number 3, 4, and 6, we have served the notice through paper publication, and the notice has been, no order has been passed on 26/11/2024. So notice is complete. Notice is deemed to be complete.
Okay.
Okay. So my lord, there was no issues over the land. But when the two-lane construction came, the private respondents, they started claiming ownership over the land. So that is how the two village councils, that is the Lozami Village Council and the Lozabuhu Village Council, they had a joint court sitting, and they have decided, they have elected their own sessional chairman and sessional secretary, and they have decided on the issue. My lord, that annexure is at page number 18. The type copy is at page number 18. Page 18 of my writ petition.
Yes.
My lord, I may be allowed to read out. 21st February 2021, the joint court of Losami Village Council and Lozabuhu Village Council had meeting on 21st February 2021 at Lanizo Village to settle the land dispute with Tita The meeting was presided by Mr. Such and Such, VDP Secretary, cum VCM of Loza Buhur, while Mr. Miwe Such and Such, Judicial Secretary, Losami as Session Secretary. Mr. Such and Such, VCC Losami, invoke God's blessings for smooth proceeding of the meeting. The joint court unanimously resolved the following. Number one, the joint court resolved that the compensation money for Loza Kiri Bridge, Chenich line length 111 plus 640 to 113 plus 230 CL shall be equally distributed to all the disputed landowners. The joint court also resolved that the above national highway shall be owned by Loza Buhur and below national highway shall be owned by Losami. 3. The joint court also resolved that the distributed portion that have any dispute shall be settled by their respective village councils. So, my lord, this is the decision rendered. In reality, the petitioner here is the only landowner of the disputed land. But these private respondents, they started claiming ownership over the land just because the two land compensation was to be released. So that is how this joint court had a sitting and they decided in this manner. But as per the rules for administration of justice and police in Nagaland 37, there are only 6 courts recognized by this act, by these rules. My lord, if you, my lord may kindly come to page 8 of my writ petition, page 8, para 4. Page 8, para 4. Page 8, para 4. If my lord.
Yes.
Yes, my lord. My lord, I may be allowed to read para 4.
Yes,
That it is humbly stated that under the rules for the administration of justice and police in Nagaland 1937, there are only 6 courts which are recognized by the law, namely number A, Deputy Commissioner, number B, Additional Deputy Commissioner, number C, Assistant to Deputy Commissioner, number D, Customary Courts, that is Topashi Courts, and number E is Village Authority, and number F is Tribal Courts. So this joint court, joint court is not a recognized court. At the most, these matters can be taken up by subordinate courts, subordinate district customary courts, because this is between 2 villages. So those kind of cases can be dealt by subordinate district customary court. But this subordinate district customary court, it is not implemented in the state of Nagaland so far, because Rule 4A, Chapter 4A of the Rules of Administration of Justice is yet to be implemented in the state of Nagaland so far. So at the most, these kind of cases can be dealt by subordinate customary courts. However, it is not constituted in the state of Nagaland. So the very
Now,
court,
whether these Loshami Village Council
and
Loza Fuhu Village Council can be regarded as village authority.
no, my lord. My lord, these are 2 different villages. These are 2 different villages and having different jurisdiction. So these kind of cases cannot be dealt by the village court. There has to be a subordinate customary courts, or else in other way by the district magistrate, deputy commissioner of the district. Because especially in this case, in the present case, this is something to do with land compensation. So the Land Requisition and Acquisition Act will come into play. So when that happens, the district magistrate, that is the deputy commissioner, has the authority to decide over the issues.
Which is the provision in rules of administration of justice and police, classifying the different category of courts.
My lord, if my lord may kindly come to page 27. Page 27 of the rules, page 27.
Yes.
My lord.
Rule
Clause
23.
Yes. Administration of civil justice in the state of Nagaland is entrusted to the Deputy Commissioner, Additional Deputy Commissioner, Assistant to Deputy Commissioner, customary courts constituted under Chapter 4A of the rules, Topashi and other village authority. May be appointed by the state government from time to time by the notification in the official gazette. That is the council. May also kindly come to page 54 of the rules. page 54. The heading is at page 53. This is chapter 4A, rules 42, rules 42. This is subordinate district customary court. The heading is district subordinate customary court. And my lord, if at page number 54, the rules 43, if I may be allowed to read out this rules 43.
Yes.
The jurisdiction of the district, subordinate district customary court shall extend to suits and cases arising within the territorial jurisdiction of the state court between parties residing within the jurisdiction of different village courts. Therefore, cases which are not triable by the village courts and cases involving dispute between villages falling within the territorial jurisdiction of the state court. So when the dispute is between the outside the jurisdiction of two villages, it can be dealt by the subordinate customary court. And
Now, these subordinate district customary courts are,
Yes.
whether they are in existence?
no, because chapter 4A of the rules of these rules is not implemented in the state of Nagaland so far.
Okay.
So at the most, this matter has to be referred to Deputy Commissioner because this is something to do with Land Requisition and Acquisition Act, and this is something to do with compensation of the raising out of a compensation. So the district magistrate or the Deputy Commissioner has the authority over the issues. So my humble prayer in this petition is to direct the Deputy Commissioner to decide over the issue, to decide the present issue. So, my lord,
Okay, this much.
that is the main crux. That is the main crux of the issue. There is an issue and money and the compensation amount allotted in respect of the present disputed land is 8,37,124 rupees, which I have annexed as annexure at page 22 of my writ petition, page 21 and 22.
The land has been acquired
Yes.
for construction of,
Everything is settled, survey is done, and just the compensation amount is with the in the Deputy Commissioner's office. So there is a, while moving this writ petition, there is a stay passed by this honorable court not to disperse the compensation amount in respect of this land. So it is my humble prayer that Deputy Commissioner may be directed to dispose of the present issue.
yes.
Even the
that's right.
compensated amount is in his account.
Yeah.
Lordship, in fact, the state is just a performer respondents here because the petitioner is not aggrieved by any of the actions of the state respondents.
Yes.
He is aggrieved by the actions of the private respondent only.
Yes.
Having said that, Your Lordship, in the village, in the Nagaland Village Councils Act that is amended up in 2022.
Nagaland Village Council.
Council Act, Nagaland Village and Tribal Council Act 1978, and it has been amended in 2022. Lordship, I agree with the submissions of the Petitioners Council here. For at Rule 14.2,
Yes, what it says.
it says, in cases of disputes between or among villages, the Deputy Commissioner,
Rule,
if the
rule 14.
two.
Two.
Two. In case of disputes between or among villages, the Deputy Commissioner, if the village falls within the same district, or the Commissioner Nagaland, if the district falls in different district, may take up the matter for settlement or refer the dispute to the appropriate authority for settlement. So, Your Lordship, the petitioner may approach the Deputy Commissioner with his grievance, and as empowered under Rule 14.2, the Deputy Commissioner may decide on the issue, Your Lordship. Because their limited prayer is also only that, Your Lordship.
Okay. Heard Mr. Taka.
Issue.
This is item number.
Item number 18, my lord.
Heard Mr. Taka Kichu, Learned Counsel for the Petitioner
petitioner.
also heard Mr. N. Angami, learned senior government advocate appearing for
Respondent one and two, my lord.
respondent number 1 and 2. None has appeared for the private respondents. On perusal of the records, it appears that as against respondent number by 4/10/24, the order was against which?
5, 7, 8, 9, 10, and 11.
As against respondent number 5, 7, 8,
9.
9, 10, and 11, the notices were duly served, and this court by order dated 4/10/2024 held that the notices were duly served on the said respondents. As against respondent number
3, 4, and 6.
3, 4, and 6, the notices were published through paper publication, and this court by order dated 26/11/2024 has held the notices to be duly served on the said respondents. By filing this writ petition, the petitioner is aggrieved with the order dated
21.
21/2/2022,
2021, my lord.
2021, passed in a joint court session of Losami Village Council and Lozafuhu Village Council. Stop. Learned counsel for the petitioner has submitted that the petitioner owns a plot of land known as Tida Jhum land, within bracket, also known as Chida, CHIDA, Jhum field, from one Shri K.K. Chakkesang. Stop. Chakkesang for an amount of rupees 20,000, and by executing a sale deed on
3, 5, my lord, 3, 5, 2021.
15/10, 15/4.
My lord, 15 then was a write-up, and 3, 5, 2021 was the
Executing a sale deed on 3/5/2021. The area of the said land is 3,85,000 square feet. Stop. The petitioner used the land for cultivation and the whole plot of land was free from all encumbrances. Stop. It is submitted by learned counsel for the petitioner that in the year 2020, the state government surveyed the land of the petitioner for construction of National Highway number 29, within bracket NH 150, bracket close, 2-lane construction. And your land has been acquired.
My lord, yes.
And for the said purpose, the land of entire land or portion of the land has been acquired for the state government. However, when after the acquisition of the land for the said purpose, the private respondents started claiming ownership over the land of the petitioner, when the compensation amount for acquisition of the said land was to be released by the deputy commissioner. Stop. It is submitted by learned counsel for the petitioner that on the complaints of the private respondent, the village council of Losami village and Lozafufu village had a joint court meeting and passed an order on 21st of February 2021, which is impugned in this writ petition and resolved as follows. And resolved the following. Quote para 1, 2, and 3 from page 18 of the writ petition. Learned counsel for the petitioner has submitted that the petitioner is the owner of the land which was acquired by this state for construction of National Highway 2021.
29, my lord.
29. And the village council of Losami
and Lozapuhu.
Losami village and Lozafuhu village acted beyond jurisdiction in passing the impugned resolution, passing the impugned order in a joint court meeting when they don't have jurisdiction to decide the dispute of such nature. Stop. Learned counsel for the petitioner has submitted that the dispute being in the nature of civil dispute, only the categories of courts recognized in section 23 of the Rules for Administration of Justice and Police in Nagaland 1937 are entitled to are empowered to decide such dispute. Learned counsel for the petitioner has submitted that the dispute, the dispute in this case falls within the jurisdiction of more than two village council. The appropriate forum would, under the law, would have been any of the following categories of the courts. Deputy Commissioner, Additional Deputy Commissioner, Assistant to Deputy Commissioner. The other courts or authorities which are not recognized under section 23 of the rules of administration of justice and police in Nagaland do not have the jurisdiction to decide a dispute of such nature. He also submits that now what has happened to compensation
This honorable court has passed an order staying,
in this case?
yes, my lord,
Okay.
directing the deputy commissioner not to disperse the commensurate amount.
What was the total amount?
8,37,000. 8,37,124 rupees.
For the land, for your land.
Yes, my lord.
Learned counsel for the petitioner also submits that the total compensation amount of rupees 8,37,124 has been fixed, has been ascertained as as against acquisition of the land of the petitioner for construction of the highway number, national highway number 29. However, by an order of this court
23/8/2024.
passed on 23/8/2024, an interim stay has been granted for disbursing the said amount.
Not to disperse it.
No, for interim stay has been granted not to disburse the said amount. Learned counsel for the petitioner has submitted that as the order passed in joint court session of Loshami Village Council and Lozafuhu Village Council is against against these provisions of rules of the administration of justice and police in Nagaland, as well as beyond jurisdiction of the said village council, same is required to be set aside. And the deputy commissioner may be directed to decide the dispute raised by the private respondents. On the other hand, Mr. K. Angam, where is the village councillor?
In Angami.
Sorry. Mr. N. Angami, Learned Senior Government Council, has also submitted that. You give me that.
Lordship.
Village Council Act. Which provision?
Lordship, Rule 14, Clause 2. From the amended Act 2022.
No, but it says that there can be joint sessions.
Yes, they give, no, your lordship, it says no, your lordship, that is not, the latest amendment does not say that, it's a deputy commissioner.
No, this village council, which is the go through Rule 14 Clause 2 here. Mr. Both of you can see. That has been amended.
Yes.
Which I have pointed. This, yes. it speaks about joint sessions.
2022 has
It has been amended.
That has been amended.
Yes, my lord, yes, my lord.
Rule 14.
Two.
Learned Senior Government Council also submits that as per the Nagaland Village and Tribal Councils Act 1978 as amended up to date, the Rule 14 within bracket 2 provides that the dispute between / among villages if the villages are within the same district, same has to be decided by the deputy commissioner, and if it fall within different district, it has to be decided by the commissioner Nagaland, and he therefore submits that apparently the impugn order dated 21 to 2022 2021 appears to be without jurisdiction. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. The petitioner in this case has claimed to be the owner of the disputed land, which your land falls within, no, your land does not fall within these two villages.
My lord,
The
basically-
private respondents
Yes.
are members.
my lord, basically I belong to Lusami village, Lusami village, and the road was to pass through that, and the upper portion is the Lozapohe village. So that is how both the private respondents who started claiming ownership over the land were from that Lozapohe village.
Okay.
So basically the land is in Lusami.
Okay. What was the
The petitioner in this case has claimed to be the owner of the disputed land.
disputed land on the basis of a sale deed which was executed on
3/5/2021.
3/5/2021 by one K.K. Chakesang, whom the petitioner claims to be the original owner of the disputed land. It also appears that some of the private respondents who are claiming right over the ownership over the disputed land. No, before that, the petitioner is the member of Losami village.
My lord.
And some of the private respondents who are claiming ownership over disputed land belongs to Lozafuhu village. Stop. In this case, it appears that the dispute in which district it fell?
Under Peg district, my lord.
Both the villages.
Yes, my lord.
Both the will stop. It is also pertinent to mention that both the villages, namely Losami Village Council and Lozafuhu Village Council, are situated in Feg district. Stop. Rule 14 No. The Rule 23 of the Rules for Administration of Justice and Police in Nagaland 1937 provides as follows. Court Rule 23 from page 27 of this book. Stop. Whereas Rule 14.2 of the Nagaland Village and Tribal Council Act 1978 provides as follows. Within inverted comma, 14.2, in case of disputes between / among villages, comma, the deputy commissioner, comma, if the villages fall within the same district, comma, or the commissioner, comma, Nagaland, if the villages fall within different district, comma, may take up the matter for settlement or refer the dispute to the of appropriate authorities for settlement. Stop. On perusal of the aforesaid provisions of the relevant rules, it is apparent that only 6 categories of authorities are recognized who may be interested with the administration of civil justice in the state of Nagaland, namely A. Deputy Commissioner, B. Additional Deputy Commissioner, C. Assistant to Deputy Commissioner, D. Customary courts - Dubhashis courts, E. Village Authority, F. Tribal Court. It also appears from the Rule 14.2 of the Village and Tribal Council Act 1978 that when the dispute is between / among different villages which are within the same district, the matter may be taken up for settlement by the Deputy Commissioner of the said district. Thus, next para. Thus, from the above provisions, it appears that by passing the impugn order dated 21 February 2021 in a joint court session of Losami Village Council and Lozafuhu Village Council, the said village councils have acted beyond jurisdiction and the impugn order is not tenable in law in view of the aforementioned provisions of the rules. The impugn order is therefore liable to be set aside, and this court accordingly set aside the impugn order dated 21/2/2022.
2021, my lord.
2021 on being without jurisdiction. We are referring the parties to approach
My lord.
appropriate forum instead
My
of the aggrieved party, the private respondents may approach the appropriate forum which have jurisdiction over such matter, if so advised. With above observations, this
For that matter, if the petitioner may be allowed to submit a complaint, submit a necessary application to the Deputy Commissioner.
Private respondents, The petitioner or the private
Yes, my
respondent
lord.
Yes, yes.
may approach the appropriate forum having jurisdiction over such matters for redressal of their grievance. With above observation, this writ petition is disposed of.
Deeply obliged.
My lord, if for prayer, if the deputy commissioner may also be directed to dispose of that on receiving such petition or
No,
such
that
complaint,
is-
if the
that is
deputy commissioner may be
contingent.
directed to dispose of within a period
That
of
he has to dispose of otherwise also as per the law.
or else the deputy commissioner, normally they used to keep all these such kind of cases pending for a long time. So if on receipt of such complaint or on receipt of such letter, deputy commissioner is directed to dispose the same within a period of 2 months or
No,
something like that.
Your Lordship, at this stage, they may not be necessary.
It may not be necessary.
My lord, my lord. Much obliged.
Obliged.
This book may written in.
For admission, item number 21 and 22.
May it please the lordship. Kindly see the last order that has been passed by this.
In item number 21, criminal revision petition
Three
3.
of 2025. And we have filed criminal revision 3 of 2025 and a criminal appeal 1 of 2025. In criminal revision, item number 21.
Yes, I am taking up
Yes,
item
please.
number 20.
This is have a connection with criminal appeal 1 of 2025. That's the reason why we have filed a criminal revision. I think your lordships to recollect. I think your lordship was in court number 3 in 2022, long back. So I also in between, there was some personal difficulty. I also left this case at one point of time. And the first case that was moved before that court was regarding about a provisional attachment order which was issued by the ED. And your lordship, in the first day, in spite of the serving notice to the ED, they did not appear. And I remember today also, I told the court, please do not take up the matter. Only after hearing the ED, please take up the matter. So after 1 or 2 attempts, the ED appeared and thereafter some orders were passed. Then further we challenged the predicate offense, then also the ECR also was put to challenge, but somehow there was some interim order passed. Somehow some counsel appeared and they decided to withdraw this case. And ultimately, the money laundering case started before the learned trial court, 1 of 2024. In between, I have been told, and I appearing in some case, that they also have challenged the complaint that has been filed before the learned trial court. But there was no interim order that has been passed by this court. So money laundering case has already started. So that is money laundering case 1 of 2024. Now,
Where you are one of the accused.
I am one of the accused in this case. Out of 295, 300 accused, I am one of the accused. Out of 300 accused, I am one of the accused.
Okay.
One of the accused. Now, my lord.
That is case
yes.
number money laundering.
Money laundering case number is 1 of ML 1 of 2024. That is in Dimapur, special judge, PMLA, Dimapur.
Yes.
Now, my lord, why this criminal division has been put to challenge when the money laundering 1 of 2024?
What are you challenging in
Now, this is important. I am challenging in criminal division order of 13/12/2024, which your lordship will find on page 29.
Kindly look at page 29. This is the order that has been passed.
Who is, you are for the other side?
ED.
Okay, only ED is the party,
Yes,
state is,
ED. ED is a party, my lord. PML.
okay.
Now
Yes.
time, see 13/12/2024. This is the impugn order at page 29, my lord. May I read this order, my lord?
Yes.
Learned SPP, see so and so present for the company ED along with deputy director. Now, learned counsel, see Amit Singh present for accused number 1, 2. So we are concerned about 1. Also file exemption application for accused number 1 and 3, being IA number 920 and 921 of 2024. Since with regard to A1, this court has, by this order dated 5/9/2024, while disposing the IA 53 of 2024, it will be, my lord, 531. As wrongly it is 553. I'll show it. It is 531 of 2024. Directed the A1 to be present in person. However, A1 has failed to comply with the direction of this court. Hence, bailable warrant, non-bailable warrant issued against the A1, which was kept in abeyance, be executed. So this is what we are putting to challenge. So now, if this is to be, my lord, looked into it, your lordship has to look into what is the order that has been passed in 5/9/2024, because that is the basis of what the court has come to a finding. Why this non-bailable warrant, which was kept in abeyance, be executed because of the basis of the order of 5/9/2024. So before your lordship looks into, I will show it, but your lordship has to look the basis and foundation, how the case started. Because for the convenience of the court, what I have done, kindly see at page 34 now. This is how the case started. Then we will look into 5/9/2024. First order, that 34. So what is this 5/9/2000 at page 34, 22nd, 22/3/2024?
Yes.
Because this is the initiation of the proceeding. Now, my lord will kindly see, this is the first order. Heard Mr. So-and-so, a complaint under section 44 and 45 of prevention of money laundering is received along with report of investigation in the form of charge sheet from the offense made punishable under section 4 of PMLA against the accused, see Bhupesh Chawla and 298 others. From the perusal of the charge sheet and the accompanying material placed on record, there being a prima facie case, cognizance is taken for the offense of money laundering and the case record is taken into my file. Register this case as money laundering case number so and so. Issue summon to all the 299 accused persons made returnable on 24/5/2024 for supply of copies. Now I'll just state, your lordship has read this order along with me. I have read. Summon was issued, my lord, keeping it on next date on 24/5/2024. Now, my lord, in this case, A1 was never made an absconder, or ED didn't direct press for the appearance of the accused in the first date on 22/3/2024. Because I have to be named as an absconder, I will show it. I have not been named as an absconder. Neither on the very first day, they have not said that his presence is personally required. Only summons to be issued. So summons has been issued to all the 299. Now, if your lordship looks into the second order at page 35, 24/5/2024.
Next day.
Sometime. My lord will kindly see so and so learned counsel for ED. Also present so and so. Mr. Hemant Shah, learned counsel for accused number 1. So we are accused number 1. So I am here for accused number 1. So your lordship will just see they are addressing. See page 36. Which counsel appeared for whom? We are not concerned. 36, kindly see. Next page. Learned counsel for ED is present along with the IO, and they are to furnish copy to the learned counsel for the parties for argument on charge on 2/8/2024. Now, my lord will kindly skip that line for meanwhile, sir, for hearing on the exemption application on 7/6/2024. So, my lord, what the order stipulates, what the order says, that they have to furnish the copies to the learned counsel for the parties who appeared on that date, and argument on charge was fixed on 2/8/2024. And I also file an application, hearing on application, exemption application on 7/6/2024. Now, 7/6/2024, kindly see the next order. None appear for ED. 36 down below.
Yes.
7/6/2024, none appeared for the ED. 37, now your lordship will go down below. 37 on the last paragraph, last line, 2 lines, application for exemption of A1, that is the petitioner, and an application for hearing of the case in hybrid mode will be heard separately. Now please turn to page 38. Heard the arguments of learned counsel, the matter is part heard. Mr. Y.P. Gupta, learned SPP for ED, makes his subsequent appearance and files his written reply to the application and also make his submission. The order is kept reserved. Now this is very interesting. Your lordship has looked into at page 36. If your lordship looks at page 36, for argument on charge on 2/8/2024, that means ordinary course of the business of the court was fixed on 2/8/2024. That is at page 36. Lordship got it?
Yes.
Now, if your lordship in between 7/6 was the date, so all the respective counsel appeared and the application was filed for exemption. And the court said at page 37 that it will be heard separately. And in the meantime, it was kept reserved. Now, next date, course of the ordinary course of the court business was on 2/8/2024. But your lordship will kindly note down, this is what we are. On 2/7, I have just see at page 38. Before 2/8/2024, your lordship will please mark on 2/7/2024, and of date, an application was filed by the ED.
Yes.
Now that application was filed by the ED for issuance of non-bailable warrant of arrest.
Okay, it is not mentioned.
That's I will show it, my lord. There is an order. At page 60 is the order. I will show it. Page 60, if your lordship looks into it, then it will be easier. Let us read. Then I will go to 5/9/2024 order. Please look into 2/7/2024, the order at page 60. See at order at page 60.
Yes.
This is a total and ex parte, and that one off date. Kindly see 60, IA 230 on the top. Kindly see on the top, IA 230 of 2024. Your lordship got it, my lord?
Yes.
And see the date of the order. IA of 2020, 230 of 2024. Please mark this, my lord. 230 of 2024. Now, your lordship, kindly see date for the applicant YP Gupta. Date of the order is 2/7/2024. No, none appeared for the petitioner in this case. None appeared. It is out and an ex parte. Kindly see the second paragraph. Present YP Gupta, learned special PP for the enforcement director, heard learned counsel and peruse the records. See 02. The instant application under section 70 CRPC read with section 65 of the Prevention of Money Laundering Act. So and so is filed by the complainant, applicant, the Directorate of Enforcement through his Assistant Director Dimapur, praying for issuance of open-ended non-bailable warrant of arrest against the accused, Mr. Bhupesh Arora. It is submitted by learned so and so, based on a complaint so and so. Your lordship will, this is the allegation which has been leveled. We are on the procedure. Kindly see the next page, 61, the second paragraph. These are all the allegation. We are on a procedure. The learned SPP submits, your lordship got it?
Yes.
That is summons under section 52 of the PMLA dated 13/1/2023, 23/2023, 15/2023, 27/9/2023, 18/12/2023, and 21/2/2024 were issued to the accused Bhupesh Arora, but he never appeared before the investigation agency. Even the order dated 25/9/2023 of the Honorable Gauhati High Court Kohima bench to cooperate with the investigation was not complied by the accused. It is submitted. Accused is evading the investigation and deliberately not joining the investigation and is presently absconding. It is also submitted. Presence of the accused is required by the investigating agency for collecting evidence and also pertinent information which is within his personal knowledge and exclusive domain. The non-cooperation by the accused is delaying the proceeding, and there is reasonable apprehension accused is trying to alienate his movable, immovable assets and tamper with the evidence, and is believed that the accused is presently absconding at Dubai. As such, the learned SPP submits all the possible effort to secure the presence of the accused before the investigating agency has failed due to his non-cooperation, and prays for issuance of a non-open-ended, non-bailable warrant of arrest against the accused person. I have considered the above submission advanced by the learned SPP for the applicant. As so now 1, 2, 3, though, now kindly see first, second, third, fourth, fifth line. Though he, your lordship got it?
He did not.
Though he did respond via email to someone dated 23/2/2023 and 18/12/2023, citing medical reasons at the last summon dated 21/2/2024, praying for a few weeks, he never appeared before the IO. Even the order dated 25/9/2023, passed by the Honorable Gauhati High Court at Kohima bench in the writ petition filed by the accused writ petition criminal number 3 of 2023, wherein accused was directed to cooperate with the investigation, was never complied with by the accused. As such, from the aforesaid, I am satisfied accused is not cooperating with the investigation, and that his presence before the investigation agency is necessary. And now it is shown that the accused is absconding and stationed at Dubai. Prayer of the application is being allowed.
Whether investigation is going on?
No.
Charge sheet has already been laid.
Late. So that is one aspect. Your lordship has understood. No, only why I am saying
yes,
summons procedure case, my lord. Now, my lord will kindly that learned trial judge, my lord, ultimately they realized what I am showing. 5 now we have against this order, my lord, we have filed a petition for recalling of the order 531. Now the learned trial court has realized thereafter, my lord. If your lordship kindly see the order. Now if your lordship looks into the impugned order at page 29, if your lordship please turn to page 29. Yes, if your lordship at page 29, impugned order, which I said that why we are before this honorable court, agree by this order, page 29, which for the first I have shown, my lord. 29, yes. Only 3 lines, reasons, or the reasons which cited, since first, second, third line, or since with regard to A1, lordship got it?
Yes, since
with regard to A1, this court has wiped its order dated 5/9/2024 while disposing IA 531 of 2024 directed the A1 to be present in person. However, A1 has failed to comply with direction of this court. Hence, non-bailable warrant issued against A1, which was kept in abeyance.
What is 531?
And now I will show at page 63. See the order of 530 at page 63, which is the order of 5/9/2024 order. So, all counsel were present, not an ex parte order. At page 63.
Yes.
See on the top, my lord, IA number 531 of 2024. See the date of order 5/9/2024. Now, argument of learning was heard earlier in the day. Order was kept reserved. Hence the following orders. Kindly see 02. The instant application under section 17(2) BNS is filed by the filed by the accused petitioner Bhupesh Arora, praying for recalling and or cancelling the order dated 2/7/2024. That is, your lordship has looked in 2/7/2024 is at page 60, wherein a non-bailable warrant of arrest was issued against him. It is submitted by learned counsel for the accused petitioner for taking cognizance. Summon was issued and the accused appeared through counsel on that date fixed on 24/5/2024, and the next date was fixed on 2/8/2024. However, this court on the pair of ED has issued the impugn order dated 2/7/2024. Learned counsel submits accused petitioner was not arrested during the course of investigation, and the accused petitioner was not course of investigation, and the ED cannot pray for issuance of non-bailable warrant of arrest against the accused petitioner without showing him absent as an absconder. As such, learned counsel prays for recalling and or cancelling the non-bailable warrant of arrest issued against the accused petitioner in support of his argument so and so. In Tarsem Lal versus Director of Enforcement, paragraph 30 was quoted. Once cognizance is taken by the offense punishable under section 4 PMLA, special court is seized of the matter. After the cognizance is taken, ED and the other authority named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. The reason is that the accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after cognizance of the complaint under section 44(1)(b) of PMLA is taken by the court, ED and the other authorities named in section 19 are powerless to arrest an accused named in the complaint. Hence, in such a case, an apprehension and ED will arrest such an accused by exercising power under section 19 can never exist. Now, this is the judgment laid by the Supreme Court, my lord. At Tarsem Ali is Supreme Court judgment. Tarsem Lal, Lordship. Please mark Honorable Supreme Court at para 30, 2024. This is the latest judgment, 2024. Now, kindly see the next judgment, Delhi High Court. In the present case, para 21 is quoted.
Yes.
These two, kindly, in Director of Enforcement so and so, the Honorable Delhi High Court observed, in the present case, as pointed out herein above, open-ended non-bailable warrant remained unexecuted till the complaint was filed and cognizance was taken by learned special court. It is also relevant to note that the said non-bailable warrants were never returned to the learned special court. In the present complaint, respondent is not being shown as an absconder. There is no mention of non-bailable warrant being issued during the course of investigation in the complaint. The guidelines in so and so Basin do not specifically provide for a factual situation as in the present case. But the principle called out from the said guideline is that it is the duty of the investigating officer to inform the learned trial court about the unexecuted non-bailable warrant at the time of filing of the complaint. Non-bailable warrant technically did remain in force, but once the respondent has been charge sheeted without showing him as an absconder, same should not have been executed and rather should have been returned unexecuted before the learned special court at the time of filing of the complaint. Article 21 of the Constitution of India provides no person shall be deprived of his life and personal liberty except according to procedure established by law. It is further settled law that the procedure established by law should be just, fair, and reasonable and not arbitrary. The arrest of the respondent in pursuance of a non-bailable warrant cannot be termed as just, fair, and reasonable, even if the respondent was detained on the basis of a lookout circular in pursuance of the said non-bailable warrant. There was no compulsion for the department to arrest the respondent on the basis of the same. It is not the case of department. Arrest was made in exercise of power under section 19 of the PML Act. So relying on these two judgments, on the judgment of Delhi High Court as well as Supreme Court, how the court has come to a finding, I will just skip this at page 66. What is the finding? At page 66, which is, with greatest respect to the learned trial court, this has been overlooked, my lord. And that order has been passed. Kindly see 66. After 05, my lord, that has been quoted in the instant case. Third para, in the instant case, lordship got it? After, I have considered above rival submission of top 05.
Yes.
I have considered in the instant case, the accused petitioner was not arrested during the course of investigation, as he was absconding and evading arrest as claimed by ED, but he was not shown as absconder. But be that as it may, the ED can still seek custody even though the accused was never arrested. But after hearing the accused as per Tarshem Lal, as noted above, the application of the ED praying for open-ended non-bailable warrant of arrest was heard without affording an opportunity to the accused. As such, I am of the opinion application of the ED praying for open-ended non-bailable warrant of arrest be reheard, giving an opportunity of hearing to the accused petitioner. Now, this is very important. Next paragraph. Application of the ED will be reheard on the next returnable date, which is fixed on 18/10/2024. ED is to supply a copy of their application to the accused petitioner through counsel. Meanwhile, my lord will kindly note down. Meanwhile, the non-bailable warrant of arrest issued against the accused petitioner, namely Bhupesh Chawla, is kept in abeyance till the next returnable date. The accused petitioner is to be personally present on the next day, that is 18/10/2024. With the above direction, observe the instant ISO is still stand disposed of accordingly. So now the case, if your lordship looks into the impugn order, see that impugn order. See the impugn order that has been passed by the learned trial court, special judge, my lord, at page 29. Totally, my lord, bestraight the subsequent finding of the court. See that since with regard to A1, again, my lord, at page 29, third line, since with regard to A1, this court wide order dated 5/9/2024, while disposing, direct A1 to be present in person. However, A1 has failed to comply with direction of the case.
Where is that direction?
The direction is, where is that? See, once again, where there is no direction as such, my lord. Where is that direction? What is the outcome? IA 230 of 2024 will be reheard. Kindly see at
And
page
therefore,
66.
where is that direction to remain present?
That present, kindly see the at second last paragraph, last 66, page 66, page 66. See page 66.
Oh,
Meanwhile,
accused person,
the accused petitioner is to be personally present on the next date.
Okay.
Next date is 18/10/2024. 18/10/2024 was the next date. I will show it, my lord. Our next date fixed on 18/10/2024. So now let us see what is there in 18/10. Kindly see 18/10/2024. My lord, at page 41. My lord, kindly see at page 42. See page 42.
Yes. 18.
See at page 41. Please see page 41 first. See page 41. Kindly see page 41. 5/9/2024.
Yes.
The order of 5/9. Present so and so, heard argument, learned counsel, order is kept reserved, which I read the order. Now, my lord will kindly see 42. What is happened 18/10?
Yes.
18/10/2024. Lordship got it?
Yes.
Learned counsel so and so present, accused number 1, 2, 3. So no, we have 1. Please keep 1. We are on 1. We were representing Amit Singh, represented for the accused number 1. Lordship will kindly mark this. So we were represented by the counsel for the accused number 1, Amit Singh. Lordship got it? Please turn to page 43 now. Last paragraph. Learned counsel, see, Amit Singh appeared for accused number 1, has apprised this court that application IA 230 of 2024 is pending disposal because there was no order passed. Reheard, my lord. Lordship has looked into it, the order of 5/9/2024. So he makes a prayer before the court saying that he is pending disposal where the complaint was filed for non-bailable warrant for accused number 1. The learned counsel submitted copy of the IA application has not been served. Learned special PP submitted before the court. Copy will be served today before this court for accused number 1. Now, my lord will kindly mark. Let the application IA 230 or 2024 be listed on 12/12/2024. Meanwhile, my lord will kindly mark the interim order dated IA 531 of 2024 shall continue till the next date.
That means the warrant was kept
Kept in
abeyance.
Any personal appearance which was exempted to be, my lord, appeared on 1810. So 1810, this is the order. And 1810, kindly see at page 44 with regard to accused person, third paragraph. 44, with regard to the accused person who has been represented by the counsel, their personal appearance has been exempted for today. Now fixing 13/12/2000, fixing on 13/12/2024 for appearance. So these two dates are very important. At page 44, one is 12/12/2024. Kindly see, my lord, at page 44 on the top, 230 of 2024 will be reheard. And till then, my lord, it is being to be reheard. The non-bail warrant has been kept in abeyance, and my personal appearance has been exempted. So listed on 12/12/2024. Now down, fixing 13/12/2024 for appearance. Lordship got it?
Yes.
So 5/9/2024 direction which your lordship has read to be present on the next date, that is 18/10/2024 has been dispensed. Third paragraph. Kindly see.
Yes.
Am I clear to you,
for
lordship?
that day.
Oh, that day. Always will be that day only. Whenever your lordship knows that application has to be filed. Direction to be present on that date. Next date. So 1810 I appeared and I filed an appeal, then they have exempted and said 230 will be reheard. Which date? On 12/12/2024. Now now my lord will kindly note down. Very, very important. 24/10/2024, again on an off date. Page 44.
Yes.
Now on an off date, again an IA has been filed by ED, which is 7/91 of 2024. Kindly see, CR put up along with IA number 791 of 2024, filed by the complaint ED through learned so and so, praying for declaration of the accused as fugitive economic offender and confiscation of property thereof. Next page, my lord. Under section 10/12, fugitive economic offender, I have perused the application. According issue notice to all the respondent as listed in IA, fixing 12/12, my lord, for reply and hearing on IA, issue notice of this application to the accused person also through their counsel appearing in the main complaint case. So now, when your lordship has looked at page 44, 230 will be reheard, which has been, my lord, the court.
230 for issuance of
Non-bailable warrant, which has been kept in abeyance.
Yes.
It will be reheard. And my personal exemption, personal appearance was also exempted. Now, if that be the case, and this has been fixed on 12/12/2024, in the meantime, the interim order gets extended till the next date, 13/12, at page 44.
Yes.
So now of date, they file before the court an application declaring me as a fugitive economic offender. Now I'm putting a question myself. I'll come later on. 24/10/2024, your lordship will kindly mark that. Of date, you moved a matter and you have prayed before the court by filing an IA 791 of 2024, declaring me as a fugitive economic offender under 2F. What is 2F? Pending warrant. FEO, kindly look into it. That is why I'm saying there is a connection with the second case. together, my lord, it is better that your lordship will kindly look into that. See that definition of fugitive economic offender, 2F. 2F. At page 3, my lord, 2F.
Yes.
Fugitive economic offender means any individual against whom a warrant for arrest in relation to scheduled offense has been issued by any court in India who has left India so and so. Now the first sentence, if your lordship looks into it, whom individual against whom a warrant for arrest in relation to has been so. So the warrant of arrest against any individual has to be pending. Now, so where is that, my lord? If your lordship looks into it, the application on 24/10/2024, there was no valid warrant of arrest that was pending because that was kept in abeyance by the court. 24/10, it was kept in abeyance when? 12/12. So where is the question of you moving an application for declaring me as a fugitive economic offender? Your 24/10/2024 application is premature. Only after hearing IA 2030.
After issuance of warrant.
Yes, after disposing, only then you can file it. So under section 4, they moved an application. Kindly see that 791 has been moved under section 4. Kindly see of the Fugitive Economic Offender Act. Kindly see section 4. See a section 4, my lord, on the top, where the director or any of officer not below the rank of deputy director authorized by director for the purpose of this section has reason for such belief to be recorded in writing on the basis of material in his possession that any individual is a fugitive economic offender, he may file an application in such form and manner as been prescribed in the special code that such individual may be declared as a fugitive economic offender. So now, declared as a fugitive economic offender, we have to go to the definition of 2F. So they have to satisfy the code. Definition they have to satisfy.
But this petition has not been disposed of.
Yes.
It is pending.
Yes. Still pending. Still pending. And in what manner, your lordship, I don't know.
How this has a relation with the impugn order?
Yes, I'll tell you, lordship, how it has got a relation with these impugn orders. Now, today, your lordship has looked into the entire case. 13/12/2024 is the impugn order which you are being challenged before the revision application.
Whereby non-bailable warrant.
One has. So, on the face of it, and the non-bailable warrant has been issued on the basis of 5/9/2024 order. Now, your lordship has read the 5/9/2024. Now, that 5/9/2024, the learned special judge was totally, I'll use it totally, my lord, erred. Learned special judge has erred because 5/9/2024 has not been read wholly. One portion has been read because 5/9/2024 has two paragraphs, last two paragraphs, where it says non-bailable warrant of arrest has been kept in abeyance. So where is the question, my lord, on that issuance was kept in abeyance be executed? Now today, if your lordship is satisfied that this order would not have been passed, could not have been passed by the learned trial court, the learned special judge, because 5/9/2024 order is very clear. It was kept in abeyance, and the interim order was continued till the next date on 12/12/2024, and 230 was restored in the file. And what has happened on 12/12/2024? Kindly see at page 46. See page 46. Twelve 2024. Learned counsels were present and file an appeal deferring the proceeding case accused number 1, assailing the orders of Honorable High Court in WPC 26/24. Prays for time to file a reply. Since the principal counsel for the complaint is absent, let the IA is also taken up tomorrow along with the main complaint case. So IA was 791 and 230 of 2024. That was two IAs. And what is that 226 of 2024? That is pending before this court, challenging the entire complaint. But there was no stay. So that is why the entire case proceeded before the learned trial court. But what is IA of 230 of 2024 was not heard. The mainly IA of 230 of 2024 should have been heard. And 13/12 was the next date which was fixed. After 12/12/2024, next date was fixed on 13/12/2024, which your lordship at page 29, which we are aggrieved.
Where is order dated 5/9/2024?
5/9/2024, your lordship will find at page 63, ma'am. At page 63. 5/9/2024.
It is a long order.
Yes, that's what I have read the order, my lord.
Yes.
5/9. On the basis of what? On the basis of this, my lord, 13/12/2024, a non-bailable warrant was issued.
And the direction was to you to appear on the next day,
On 18/10.
on 18/10.
Yes.
Where is the 18/10 order?
18/10 order, your lordship will find at page 42. Page 42. Page 42. Page 42 is the order. 43, kindly look into it. 43. 42 is 18/10/2024. Turn to page 43.
44.
44. Yes, accused, let the IA 230 of 2024 be listed on 12/12/2024. Meanwhile, the interim order IA 531 of 2024 shall continue till the next date. With regard to the accused person, third paragraph, who has been represented by the learned counsels, their personal appearance has been exempted for today. So the order of 5/9/2024 has virtually merged with the order of 18/10/2024. 18/10/2024. So, my lord, the order which was passed by the learned special judge at page 29, with great respect, my submission would be, this order would not have been passed. Because if you look into 5/9/2024 order.
Okay.
Am I clear to your lordship, my lord?
In 5/9, you were directed to present on the next day.
Yes.
That was on
18/10/2024.
On 18/10/2024, your counsel appeared and your personal appearance was dispensed with on that day.
Correct.
And was there any direction?
Never, I find there is no direction.
Then, okay.
No direction.
And the main ground for issuance of non-bailable warrant of arrest against you by the impugn order dated 13/12 is that you violated the directions of
Correct.
5/9/2024.
2024. So this is the sort. So if your lordship prima facie is satisfied that this is a case to be interfered, so what happens? His application, then automatically 22, which have been declared as a fugitive economic offender, that also has to be interfered by the court. Because 230.
No, you have not yet declared. You have been
Yeah, I have been declared. Appeal is there.
or separate matter is there.
Yes, that's the whole problem. They have declared. And how I can be declared? While you move the application, IA 791 of 2024 on 24th.
So in this case, you are challenging only 1312.
Yes, correct.
Which apparently appears
Yes.
That the court itself dispensed with your personal appearance
Yes.
on 1812.
Yes.
So the question of non-compliance can not again be raised.
Yes.
On that.
That's the case.
That is in revision petition.
Yes, correct. And 230, my lord, 230 IA 230 of 2024 were restored. And the
231 is still pending.
230 is still pending. That was not heard. What the learned special judge should have said. That forget all this. I will hear 230 of 2024. That was not heard. 230 was never heard. So where is the question of the execution of my non-bailable warrant? There is no question of execution on a non-bail warrant, which was recalled by order dated 5/9/2024 in IA 531 of 2024.
Yes, the warrant was not recalled, it was suspended.
It was kept in abeyance.
Kept in abeyance.
Why? What is kept in abeyance? What do you mean by kept in abeyance?
It is not in force now.
That's what is important. You can't say that particular, unless it is cancelled, it is still in force. There is we move matters. There is a stay of that particular orders, impugn order. At that relevant time, my lord, till it is disposed of, that is not in force.
Okay. So in appeal, you have challenged which order?
Criminal appeal, we challenge 22/1/2025.
Separate order by which
Separate
you
order
were
where we have been declared as a
fugitive.
economic order, because that's an appeal which has been disposed of by appealable order, madam. And this is a revisional order.
And there also your ground remains same.
There are another grounds, there are other grounds.
So let us first.
This is important. That's why what I was suggesting, subject to your lordship's, what my learned friend says. If this, your lordship will hear my learned friend, what he wants to say about criminal petition 3 of 2024. Whether it is a case of interference or it is not a case of interference. He has to argue on this first.
So we'll take it, we'll finish first revision.
Yes. Yes.
And please, your lordship, I've submitted my endorsement letter on 7th.
No,
7th February, the 7th March. However, I have prayed before this honorable court that the revision petition and criminal appeal one, the court had allowed me to file affidavit in reply after 4 weeks' time. And the IA 4 of 25 is fixed for hearing on 13th March 2025.
I for what?
For staying here.
I must explain to your
Yes,
lordship what has happened when the matter was taken up by this court.
No, my one query is,
yes,
there are two issues which are connected, but which can be dealt separately also. Can we consider and dispose of the revision petition first?
You know, regarding
It has to be done.
regarding about revision petitions, the court has allowed me to file affidavit in reply, granted me 4 weeks time on 7th March 2024.
there is no problem.
And it fixed.
But what is there? And or
fixed.
stay the operation of the impute. Whenever revision application is being filed, it is always a prayer is made, pending disposal, your lordship.
So you are praying for interim?
Yes, I have paid at page 25. Page 25. We have subbed the copy. They should have read
Okay,
this.
we'll hear you.
Yes.
You want to file an objection against the revision
Yes,
petition.
your lordship.
But interim has to be heard.
Yes.
today. We'll hear at 2 after lunch.
Yes.
Mr. Lordship, with your permission, Lordship, I've taken the consent of the party who are arguing. Lordship, to kindly update item number 24, because the contempt, the order which is under contempt has
Has been-
already been complied, so to close that matter, your Lordship.
24. Yes.
Yes, Lordship, the order dated 33/2022
Ye-
has already
you-
been complied. Yes, I have the regularization order.
Heard Miss, what's her name? Oh, Steno. Heard Miss, what is the name? Alito Zoo. Learned counsel for the petitioner. Also heard Miss V. Sokre, learned additional advocate general,
For respondent 1, 2, 3, and 5.
appearing for respondent number 1, 2, 3, and 5. You are also appearing. Also heard Mr. Kivia Angami, learned government advocate, appearing for respondent number 4. Learned additional advocate general has submitted that the order dated 30/8/2022 passed by this court in WPC number 116/2022, in respect of which this contempt petition has been filed, has already been complied with by the state respondent. And therefore, she prays for closing this contempt petition. In support of her submission, she has placed on record the office order number E-IN-C/ESTT-9/67/30 years and above/REG/2020, dated 25th February 2025, whereby the petitioner is that number says, whereby the services of the petitioners service of petitioner has been regularized with effect from 29/9/2022. Stop. In view of the submissions made by learned counsel for the, you have no objection. The learned counsel for the petitioner does not opposes the prayer. In view of the submissions made by learned additional AG and in view of the compliance of the aforesaid order, this contempt case stands closed.
Your Lordship, the regularization order may be kept on record.
Yes, let the regularization order dated, let the aforesaid office order dated 25th February 2025 be kept in record as a part of it.
May I be pleased to mention hearing item number 29, Your Lordship, on behalf of Inaholi, Your Lordship. If this matter can come up after 2 weeks, Your Lordship.
Third, Ms. Levika, learned Government Council, submitting on behalf of Ms. Ina Holly, learned Government Council, appearing for the respondent, who prays for an adjournment for 2 weeks. Mr.
For other matter.
Okay. The considering the submissions made by learned government council, you have informed the,
Yes, yes. They were in the premise, but since the matter might take
The-
time, that's why they left.
she has submitted that she has informed the learned council for the petitioner regarding her prayer for adjournment. Considering the submissions made by learned council, the prayer is allowed. List this matter after 2 weeks.
May I please your lordship? The lordship, I'm appearing for item number 27 and 28. As even the counsel for the respondent is on leave today. It was reserved for order. So as directed by the honorable court in the last order, we have served the copy of the repetition IA to respondent number 2.
So what is your submission?
So, sir,
This
like,
matter will go for admission hearing.
yes,
All parties have appeared.
yes, yes, your lordship, we have served the copy.
Heard, Mr. What is your name?
P. Rosa.
E,
Your lordship, I have submitted my.
but still you can tell your name.
P. Rosa, your lordship.
P.
P. Rosa.
Rosa.
ROS, yeah.
ROS.
U. Dot.
Okay, Rosa.
Yeah. Yes. your
Heard
lordship.
Mr. P. Rosa, learned counsel for the petitioner, who submits that in pursuant to the order passed by this court, the petitioner has furnished the copy of interlocutory application and writ petition to the learned counsel for the respondent. This case is therefore respondent. Stop. Let this matter be listed for admission hearing after 2 weeks.
Oblige, your lordship.
Please, your lordship. Lordship, item 36 and 37 of the supplementary list.
Yes.
Lordship, my learned senior colleague is likely to be back sometime. So may I believe that the matter may be listed on Monday?
Monday.
It's right.
Yeah. You are Mr. Apok Pongke.
Yes, yes.
You have informed the,
Yes. Sir.
okay.
He's outside, he's in the.
Heard
I
Mr.
think-
Apok Pongne, learned counsel for the respondent, who prays for listing this matter on 24th of March 2025. He has submitted that he has informed learned counsel for the petitioner regarding his prayer, who has no objection to the same. Stop. Considering the submission, the prayer is allowed. Let this matter be listed on 24th of March 2020.
Learned friend starts, my lord. I just want to clarify about a criminal revision which was moved before this court. So basically, there are two grounds which my learned friend should, two grounds. One first ground is that 5/9/2024 is fully compliant. So if it is fully compliant, there was no question of issuing the non-below warrant to be executed. Because the two operative portion of the order said 230 of 2024 IA is being recalled and it will be reheard. Secondly, non-bailable warrant was kept in abeyance. And my appearance, that personal appearance was exempted till 18/10/2024. 18/10/2024, I made an application for exemption, it was allowed. So there was no occasion to the order to be passed by this court on 13/12/2024 for non-compliance, because this is only 230 should have been heard. On 13/12.
230 is still pending.
Still pending.
Okay.
That's the case.
Yes. What is your name?
And now.
What?
My good name is.
My what? I just, during the break period, my learned friend said that I was only prepared with an IA, which is in criminal appeal. But I told him that criminal revision also has been filed. criminal revision, we specifically, because there is no question of filing an IA in a criminal revision petition. So what I propose, my lord, subject to your lordship convenience, that in IA, we have asked for stay of the operation of the impugn order at page 25.
In criminal appeal,
Criminal, no, my lord, revision petition.
in revision also there is an I,
Yes, revision no IA is a interim prayer.
interim prayer.
Yes. A stay of the
And
operation of
today it
the
is fixed for hearing on the,
interim prayers.
what is I 4 of 25?
IA is a criminal appeal.
Okay. So common
So
order.
can I yes, come on. He has not passed an order. He has not filed any rejoinder, any affidavit in main criminal revision petition. Because it has to be heard. So today for interim, he may get a time to file objection affidavit in the main criminal petition. There is absolutely no problem. But IA, when normally a matter is being heard by a court, normally your lordship consider whether a prima facie case has been made out or not.
Now what relief you are seeking?
What I am praying that criminal revision petition, this operation of the impugn order 13/12/2024.
Impugn order means
13/12/2024.
that non-bailable warrant which was
Yes.
issued on
Yes.
13/12.
12, that should be stayed by.
Because
13
earlier order has already been stayed by the.
Yes. 13/12/2024 order should be stayed, my lord. Till they come up and file an affidavit, that's a different thing altogether. They have to come and file an affidavit.
Yes.
This 13/12/2024 order, D and E, my lord, D and E at page 25. Page 25 of criminal revision. Criminal revision petition. D and E.
Yes.
If this is stayed, my lord, for my prima facie, if your lordship is satisfied, and your lordship can hear this on next Friday, no problem. That criminal appeal, your lordship can hear next. He can argue IA.
Yes.
I am here on this can be stayed, and in the meantime, he can, because in IA, in that case only there is an already interim order. No coercive measure in that.
Okay, Mr.
And
Toby.
what I just proposed that this D and E can be interim order till next date, and your lordship can hear it on Friday again.
Yes, Mr.
Together, I am making a very fair submission so that already in criminal appeal, there is already not to take a coercive measure, but criminal petition is being heard. So let D and E temporarily it will be stayed till the next date, returnable date. That is on Friday, it can be heard, and he will get time to prepare it.
Yes, what is your submission?
Your lordship, I'm not prepared for revision 3 of 25 and criminal appeal 1 of 25. I'm prepared for IA 4 of 25. And
But what is you have heard while the council was making submissions?
Your lordship, on 7th March 2025, I have, as I have stated earlier.
No, you will be given that already court has passed order that you are given time to file
Yes.
your written objection.
Yes.
That is
So
there,
it's-
but
it's
as regards interim prayer, what is your submission? Because prima facie it appears, if you can change my view, prima facie it appears that by the impugn order, the trial court issued non-bailable warrant of arrest only because there was violation of the order dated 5/9/2024, whereby on the next date the accused number 1 was directed to appear personally. On the next date, the counsel is always appearing, and the personal appearance was dispensed with on 18. Then it appears that, and on the date when this order was issued, on that day also the council was present. So what was the occasion for issuing non-bailable warrant of arrest? It appears to be contradictory.
Your Lord, it's falls under revision three of the 25, Your Lordship. So for whole issue of revision of 3 of 25, I will file a rejoinder. And time was waited for me.
Now you filed rejoinder. But regarding interim prayer, what is your submission? You have heard their prayer. They have prayed for stay of the impugn order till next date. That is till next Friday. Do you have any submission?
No, Your Lordship.
Hands up. No, you may, because apparently it appears, prima facie it appears. Heard in then we are not hearing the appeal today.
Yes, appeal on Friday, Your Lordship. Because there IA is more concern of the IA.
That I is for?
IA is for stay of that, the order dated 22/1/2025, declaring me as a fugitive economic offender.
But you have submitted that that IA has already been, that there is an interim relief.
No coercive measure should be taken.
Okay.
That's only, time being, no coercive. But that has to be heard. And so, Your Lordship, for what I propose that this particular prima facie case is made out, then Your Lordship will stay this DNA, stay the operation and stay the execute till the next date. And on Friday, Your Lordship can hear that one.
Friday is okay for you?
Yes.
Heard Mr. D. Das, learned senior counsel assisted by Mr. S.P. S. Das, learned counsel for the petitioner. This is in criminal revision 3 of separate order Hobo 3 of 2025. Also heard Mr. Ketovi, learned special public prosecutor.
Superior.
Special public prosecutor ED.
Yes, Your Lordship.
ED. Learned special public prosecutor has submitted that by order dated when you were granted time for 4 weeks.
7 March 2024.
By order dated 7th March 2025, the petitioner, the respondent, that is ED, was granted time for filing written objection against the writ petition, against the revision petition filed by the petitioner. And 4 weeks time was granted, and that time has not yet lapsed. Learned senior advocate, learned senior counsel for the petitioner has submitted that by the impugn order dated, learned senior counsel for the petitioner has submitted that this case may be fixed for hearing on, this revision petition may be fixed for hearing on 28. Friday may be difficult. You choose some other day.
Maybe on Thursday.
Thursday is okay.
Yeah, Thursday. Because Your Lordship is only hearing the interim only application. So on Friday, interim only, not the main hearing.
Okay, main
That's
4
only
weeks time is
interim.
okay.
4 weeks are so Friday it can be taken
line
up.
to continue. Learned senior counsel for the petitioner has however, prayed for an interim relief in the meanwhile. Stop. He submits that in the instant revision petition, the petitioner has impugned the order dated 13/12/2024. Both of you may take your seats.
Yes.
Impugned order dated 13/12/2024, passed in ML 01/2024 by the Special Judge PMLA Dimapur, whereby non-bailable warrant of arrest was issued against the present petitioner. Stop. Learned Senior Counsel has submitted that the main ground for issuance of non-bailable warrant of arrest against the present petitioner was that the petitioner failed to appear in person before the court in pursuant to the order dated 5/9/2024, passed in IA 531/2024. Stop. Learned Senior Counsel for the petitioner has, however, submitted that by order dated 5/9, has submitted that before registration of the IA number 531/2024, the trial court had, on an application made by the learned Special Public Prosecutor for ED, on 2/7/2024, in IA number 230/2024, had issued non-bailable warrant of arrest against the present petitioner without giving an opportunity to the counsel for the petitioner of being heard. Stop. Learned Senior Counsel for the petitioner has also submitted that in the ML case number 1/2024, after submission of the charge sheet, summons were issued to 299 numbers of accused persons, including the present petitioner. And after receipt of the summons, the petitioner's counsel has been appearing before the trial court regularly. Stop. He also submits that in the charge sheet, petitioner has not been shown as an absconder and no pending warrant was issued against him during investigation. Stop. Learned Counsel for the petitioner has submitted that by order dated 5/9/2024, passed in IA number
561
this order is passed in 230 or
531 of 2020. Recalling of the order of.
yes. Yes, by order dated 5/9/2024, the passed in IA number 531/2024, the trial court stayed the trial court kept the non-bailable warrant of arrest issued against the petitioner by the trial court on 2/7/2024 in abeyance and fixed the and directed the ED to supply the copy of the petition filed by them in IA number 530/2024 to the, 230/2024 and fix the matter for rehearing on 18/10/2024. By the said order, the petitioner was directed to be personally present on the next date, that is on 18/10/2024. Learned Senior Counsel for the petitioner has submitted that on 18/10/2024. Where is that order?
Final is 42. 42.
18/10/2024.
Yes.
The engaged counsel for the petitioner was present in the court and his personal appearance was
This 43 is the submission. Last paragraph. 43.
present in the
Engaged counsel for the petitioner was present in the court and his personal appearance.
and he submitted before the court that as the IA number 230/2024 is pending for disposal, and the copy of the said interlocutory application has not been furnished to the petitioner. The court directed the special PP to furnish the copy of the said interlocutory application and fix the matter for hearing on 12/12/2024. In the meanwhile, the interim order passed in IA number 531/2024 was extended till next date. Learned counsel for the petitioner has, learned senior counsel for the petitioner has submitted that as the impugn order dated, as the order passed in as the non-bailable warrant of arrest issued in pursuant to the order passed in I number 230/2024 has been kept in abeyance and as the personal appearance of the petitioner was dispensed with by the trial court on 18/10/2024, there was no occasion for the trial court to issue non-bailable warrant of arrest on 13/10/2020, 13/12/2024. Hence, he prays for staying the operation of the impugn order dated 13/12/2024 till next date, and also prays for keeping the warrant of arrest, keeping the warrant of arrest issued against him by the impugn order in abeyance till next date. You have no objection. Considering the submissions made by learned counsel for the senior counsel for the petitioner, it appears that prima facie it appears that the petitioner has not, where is the 1310 order? Petitioner does not appear to have violated the order dated. Prima facie, it appears that the order dated 5/9/2024 has not been violated by the petitioner. Hence, till the next date fixed, the operation of impugn order dated 13/12/2024 shall remain stayed. The non-bailable warrant of arrest issued in pursuant to the impugn order shall also be kept in abeyance. Shall also not kept in abeyance. Shall also remain stayed till the next date, list accordingly. On on which date?
On 28th. 28th. That is on Friday for hearing the interim.
No, not on Friday.
No, your lordship.
Thursday. Or you choose next.
No, only
next.
hearing, it is not on the hearing column, it is only for the interim. prayer.
Okay.
That is why.
Okay.
Interim.
Only
prayer.
interim.
Yeah,
The
that's what-
main
Because
because
also time to
because main will be
main
taking
will take some time. That's why on Friday for interim.
then this has to be fixed after 4 weeks.
Which one?
Revision petition.
Yes,
No.
Your Lordship.
Because for what matter it will come on
No, my lord, what your lordship has interim order has been passed
till next
till the next date.
next date will be after 4 weeks only. Because it has now the revision petition
No,
has
it's
to
okay,
be.
fine then fine. Well, what I was just saying that my learned friend want to say something on that day. Otherwise, again, they will go to higher court and say, I was not given a chance. That's why I'm saying.
Let this matter be listed again on Friday. That is on 28th of March 2025.
Because I was saying that because otherwise again, against that, I am not giving a chance. This will again.
No, I am giving them chance.
No, that's why I was saying that your lordship was given. The first day, your lordship.
On that day, what they will do?
No, on the first day, When it was moved, I didn't say that there is I told the court that please hear the other side. Even I served a copy. My learned friend was not there. I served to a PP, even
Okay.
then I said.
Okay, let it be on Friday. This interlocutory application number 4/2020.
His submission also can be recorded, my lord. Today's submission, right?
No, let it be as it is.
Yes.
Because you are not opposing the prayer today.
It's okay, fine.
The inclined Gandhi. Considering the submissions made by learned senior counsel for the petitioner, and considering the fact, learned special public prosecutor has submitted that since the ED has sought for time for filing written objection against the revision petition, he has no objection to the grant of interim relief sought for by the petitioner in this case, in revision petition. That is your submission. In IA Criminal 4, this is for the first time it is being moved.
Yes. Criminal appeal 1 of 2025. That is criminal appeal and written IA 4 of 2025.
4, you will be filing any objection?
They have filed. They have filed. If necessary, we'll file, and otherwise you can be hard on that date.
On which date?
On 28th itself, man.
Okay, on request of learned counsel for both the sides, this interlocutory application is fixed for consideration on 28th 3/2025.
And there is already interim order, no coercive measure is there.
In the criminal appeal.
Till the next date, madam.
In criminal appeal, heard learned senior counsel party Pura Likhimo. What will happen in criminal appeal? Whether records are to be called for or
No,
it can be.
everything is on record. So we are challenging one order 22/1/2025. The order we are challenging it.
So it can be heard.
It can be heard. That's what I'm saying. On 28th, it can be heard. IA has to be heard because IA they have filed. In IA 4, we have asked for.
So we'll fix it on 28th itself.
Yes, that's right. That's
On request of learned counsel for both the sides, let this matter be listed again on 28/3/2025. The interim order shall continue till next date.
Only one request, I don't know. Normally, if it can be on the top of the list, it is possible.
No, on that day you make prayer.
I'll make it.
On that day
And
you.
in the meantime, your lordship will kindly note down 2 things. That day the matter will come up. I think I should, because your lordship is sitting as a roster in this particular criminal appeal. 2 things your lordship will kindly note down in respect of criminal appeal. Fugitive economic offender, which I have already given. At least your lordship can look into it. Act.
Section 4 and
Section 2F, 2F, 4.1, section 4.1, 4.1 and 2, 4.1 and 2, and section 10. Section 10, I think section 14 or 15. Section 14 and section 14. And section 12. 10, 12, and 14. So this will have a connection with the order that has been passed on 22/1/2025.
Okay.
I'm deeply obliged, man.
For admission, item number 23.
On the last occasion, CD was called for.
It is for, CD is there.
I obtained from the PP, Your Lordship.
You are ready? Both are ready.
Yes, Lord.
Okay, what is the matter?
So I'm praying for releasing of a vehicle and on Zima, Lord. My prayer before the letter trial court was rejected, Lordship.
It is an NDPS matter.
Yes, Lordship.
What is your submission?
Lordship, my submission is that, Lordship, I'm the
You are the owner.
owner of the vehicle, Lordship.
And are you the accused also?
No, Lordship, I'm not the accused, Lordship.
Vehicle was used without your consent or with your
Without my
permission?
consent, Lordship. Without my consent.
Give it to.
Charge sheet already filed, Lordship. Trial has commenced, Lordship.
But your vehicle may be confiscated. Subject to confiscation.
Lordship.
What is the law?
Lordship.
NDPS. What is your submission?
Also, my submission is, Lordship, since the petitioner here before this honorable court, she was not aware of the offense, Lordship. It was beyond her knowledge that the vehicle was used.
Where is the rejection order?
Find it page number 26, Lordship. 26. Lordship, Cody.
Yes.
May I read the order, Lordship?
On what ground it was rejected?
Lordship, it was only on the ground that NOC was issued by the registered owner to a different person and not to the present petitioner, Lordship. Whereas, Lordship, may kindly appreciate that a sale deed was already executed between the petitioner and the registered owner, Lordship.
And the vehicle is not registered in your name. You are not the registered owner.
Lordship, yes, Lordship. I have categorically stated in my petition that I was in the process to change the ownership. There's already a sale deed which is registered, and that is also not disputed, Lordship.
Where is the reasoning for
Lordship, may
rejection?
kindly come to.
Or you may read the order. Let us.
Yes, Lordship. May I read it from the beginning, Lordship?
Yes.
It is order dated 25th November 2024. The instant Zima applications number so is filed under 451 of CRPC, praying for release of seized vehicle Suzuki Swift Desire VXI, bearing registration number so engine number so and so on Zima pending disposal of the case. The legal counsel submits that the petitioner is the aunt of the alleged accused, Mr. So, who was apprehended on 9 March 2024, along with the seized vehicle in connection with the instant case for possession, transportation of suspected heroin, and that she was neither aware nor involved in the instant case. The legal counsel further submits that the petitioner had purchased the seized vehicle from one Manoj Kumar on 14 March 2023 for consideration of rupees so and to that effect a sale deed registered as 183 of 2023 dated 14 March 2023 was executed at Dimapur and a copy is enclosed in the petition. The seized vehicle is lying unattended without proper care under police custody, which is bound to damage the vehicle. And moreover, the vehicle is used by the owner for picking and dropping of her children to school and prays to release the seized vehicle on Zima and relied her submission on the judgment of Honorable Supreme Court in Sundarabai so, which is reported in 2002-10 SSC. Honorable Rajasthan High Court in the case of Arun Kumar. Third, Honorable Gauhati High Court in the case of so. Honorable Gauhati High Court in 2023 SSC online so. The learned counsel further submits that the petitioner is willing to abide with all the terms and conditions imposed by this court and is ready to appear before the investigating agency or trial court as and when call for and is also ready to furnish adequate surety to the satisfaction of this court and prays to release the seized vehicle on Zima. Leonard PP so-and-so submits that the accused has stated that the seized vehicle belongs to his uncle so-and-so who has expired. The accused was the driving. It means that the accused was driving the vehicle alone when the vehicle was seized as per the so-and-so. It shows that the vehicle is registered in the name of Manoj Kumar. Notice have been issued to him, however, he did not appear before the IO. There is discrepancy with regard to the vehicle owner as such objected the release of the vehicle. Heard for the parties, perused the entire materials available in hand, also gone through the report of the IO with regard to the seized vehicle. On perusal of the report of the IO, it appears that the accused, Mr. So-and-so, has been arrested in the present case for recovery of 4 numbers of plastic soap boxes containing heroin powder concealed in the interior door panel behind the driver's seat. Below the driver's seat, floor framed and front co-passenger so-and-so of Maruti Suzuki Swift Desire. The accused has stated that the seized vehicle belongs to his uncle so-and-so who came to Senapati on 4th March 2024. But unfortunately passed away in a lodging named so-and-so at Senapati on 5th March 24. And on 9 March 2024, when he was taking down the vehicle to Dimapur to hand over the vehicle to his late uncle's wife, that is the present petitioner lordship, he was stopped by the AET team of DF Kohima for recovery of the seized vehicle in drugs in the vehicle. And by this instant application, petitioner is claiming herself to be the owner of the seized vehicle on the strength of a sale deed dated 14 March 23, executed between Manoj Kumar Chaudhary, the registered owner, and herself. There is discrepancy with regard to the owner of the seized vehicle. This is the observation. Assuming that a petitioner is the owner of the vehicle, the petitioner has not been able to satisfy to this court in what manner the seized vehicle has been used by the accused who states that the vehicle belongs to his late uncle so-and-so. The result of the NOC annexed to the petition shows that that Manoj intends to sell the vehicle to one so-and-so and not to the present petitioner. Besides the sale deed, no documents is presented before the court to show that she is the rightful owner of the seized vehicle. In view of the aforementioned, this court is not inclined to release the seized vehicle at this stage. Petition is dismissed and rejected.
Yes.
Lordship, my respectful submission before this in the court is there was transfer of ownership in terms of Section 54 of the Transfer of Property Act.
What is the procedure of transfer of ownership of vehicle as per MV Act?
Once once a sale deed is executed, I have to get it registered in my name, Lordship.
You have not registered.
I have not done, Lordship.
Have you taken any, when the registration was?
Lordship, I have made a
when the sale deed was executed?
14 March 2024,
14.
and it was 2023, Lordship.
2023.
And the vehicle was seized on 9 March 2024.
So almost after 1 year.
Lordship.
You have not taken steps for registration of the vehicle.
Lordship, it was also my contention before the Learned Tribe Board as well as before the Honorable Board is that I have to obtain the necessary forms. I was in the process of transferring the ownership.
Okay.
I've also made a categorical statement in my petition, Lordship.
What
Steps were taken after?
Yes, Ms. Levika.
Lordship, I think the submission is completed by the petition, Your Lordship. Let him first.
You have
complete his submission.
anything more?
Lordship, I have some authority.
Citations. Okay.
In fact, Lordship, this order was passed by Your Lordship on the 18/4/2024. Criminal petition 428 of 2024. May I take Your Lordship to the facts first, Lordship? It is such.
No, in a similar circumstance, the Jimma was granted to the owner.
Lordship.
Here the owner was not disputed,
Notice.
but in your case, the trial court has rejected only on that ground that your ownership is not confirmed. On that, if you can satisfy,
The sale deed itself speaks for itself, Lordship. And Lordship, what has happened in this case, the case that I'm relying upon, Lordship, there was an agreement executed between the registered owner and one person by the name S. Laskar, Lordship. There was an agreement executed, and the condition of the agreement is that the registered owner will sell the vehicle to Mr. S. Laskar, Lordship. Now the vehicle was seized before that transaction will happen, Lordship.
okay.
Therefore, the ownership was not transferred to the purchaser, Lordship, because there was no transaction at all. Before the transaction happened, the vehicle was seized. Now the observation, Lordship, if you Lordship may kindly allow me to refer to the relevant paragraph, page 5, paragraph number 7, Lordship.
Yes.
Paragraph 7. For mere perusal of the impugned order, it appears that the prayer for Zima was rejected by the learned special judge and DPS only because the learned APP had tendered objection before the trial court as the owner of the seized vehicle could not be ascertained. That was also in dispute, Lord. The ownership was also in dispute because of the existence of the agreement executed between the two parties. However, from the documents annexed along with this criminal petition, more specifically the certificate of registration, Lordship, I kindly appreciate the certificate of registration in original is in my custody, Lordship. It is in my custody, Lordship. It is apparent that the present petitioner is the owner of the seized vehicle, and the same is under hypothecation with Mahindra and Mahindra Finance Limited. Thus, apparently, it appears that the present petitioner is the owner of the seized vehicle. Now, this is also important, Lordship. Para 9, Lordship. Under the aforesaid circumstances, before 9, if I may be allowed to refer to paragraph 8, because this is also important for adjudication, Lordship. It is also submitted by the learned counsel for the petitioner that the seized vehicle has been lying in the police station since 28/1/2022. In my case, Lordship, it has completed 377 days, Lordship, as on today. And the same is required either for the purpose of, not required either for the purpose of investigation or in the trial. Lordship, even in my case, Lordship, charge sheet has already been filed. Trial has commenced, Lordship. It is fixed in the month of April for examination of PW1, Lordship. Cognizance of the charge sheet is already taken. Fixed for examination of PW1 in the month of April, Lordship.
Yes.
And nowhere in the charge sheet it has stated by the investigating agency that the vehicle is required any longer. I'm also ready to cooperate at any relevant point of time, Lordship. No observation of this honorable court, Lordship. Para 9. Under the aforesaid circumstances, no purpose would be served by detaining the seized vehicle under the open sky when prima facie it appears that the present petitioner is the registered owner of the seized vehicle. Hence, this criminal petition is hereby disposed of with a direction to the officer in charge of so-and-so police station to give the Zima of the seized vehicle bearing number so-and-so. By finishing so-and-so, all the conditions were laid down, Lordship. Even the vehicle in question, Lordship, is exposed for nearly 377 days, Lordship. And that there's not even a single whisper in the charge sheet, anything against me, Lordship.
Where is the sale deed?
Sale deed, Lordship. Page number 29, Lordship. Page 29, Lordship.
Okay.
This
Okay.
was executed between the registered owner and the present petitioner, Lordship. Bears registration number 182 of 2023, Lordship.
Yes. Anything else?
Lordship. So this fulfills the requirement even under the Registration Act, Lordship. as well as under the Transfer of Property Act, Lordship. And my respectful Lordship, even if I may be allowed to rely on just one single paragraph, Lordship. 2024 SCC Online SC 519, Lordship. This is a decision of the Honorable Apex Court, Lordship. I'll refer only to one paragraph, Lordship, paragraph 27, Lordship. Paragraph 27.
Yes.
This is just pertaining to failure for registration of the vehicle. 27, I'll read only the first sentence, Lordship. Mere failure to get registered the name of the new owner of an already registered vehicle does not mean that the sale deed or gift transaction would stand invalidated, and such a vehicle, despite being physically handed over to the new owner, cannot by any stretch of imagination be treated as still being in the possession and control of the former owner. This quite covers my case, Lordship. The vehicle was already handed over to me. There was a transaction. There was a sale deed which was also registered, and it is not disputed. The only question and the only ground when my petition was considered was only on the question of NOC, Lordship.
Yes.
May I please, the Lordship. Lordship, may I be pleased to refer annexure E, page 28 of the petition, Your Lordship. Your Lordship, the relevant portion, Your Lordship, page 27, Your Lordship. The last paragraph, I would like to read it again, Your Lordship, as
Yes.
yes, Your Lordship. May I read, Your Lordship?
Yes, please.
By this instant application, petitioner Zubeni is claiming herself to be the owner of the seized vehicle on the strength of a sale deed dated 14/3/2023, executed between the Manoj Kumar Chowdhury and herself. There is discrepancy with regard to the owner of the seized vehicle. Assuming that the petitioner is the owner of the vehicle, the petitioner has not been able to satisfy, explain to this court in what manner the seized vehicle has been used by the accused, who states that the vehicle belonged to his late uncle Yanchong. Okay, Your Lordship, I would like to pause here for a moment, Your Lordship. Your Lordship, the first thing is that, Your Lordship, the petitioner has not been able to satisfy the Honorable Court as to how the vehicle in question was put or given to the accused. Now the accused was driving the vehicle, Your Lordship. How did the vehicle came in possession of the petitioner? That has not been
No,
explained in the.
but that was for the investigating officer to.
Yes, Your Lordship, but Your Lordship, at least he should be able to explain, Your Lordship, as to how, Your Lordship. That is what that is my submission, Your Lordship. That is my submission, and Your Lordship, that is not being explained. And the only relation that has been averred in the petition is that she is the auntie of the accused. But no, in all the CD, Your Lordship, there is no mention of the auntie named Zubeni, Your Lordship, where that auntie has given him the vehicle to do the work, or I mean, like the vehicle has been given to him. There's mention of so many aunties, but the petitioner's name is not in the CD, Your Lordship. The petition has not mentioned the name of the petitioner, Your Lordship. Here in the petition, Your Lordship, if you get, can you come to paragraph 4, Your Lordship? Paragraph 4 of the petition, Your Lordship, of the.
Yes.
Your Lordship, that the petitioner is the auntie of the alleged accused. Now, accused, in all the CDs, Your Lordship, the accused, nowhere the accused has mentioned about this auntie. He has mentioned about so many aunties, okay, Your Lordship, but Your Lordship, there is no mention of this, and at least the petitioner should satisfy how he is related, he should establish that relation. Now, coming to the sale deed, Your Lordship. Sale deed, Your Lordship, kindly come to the sale deed, Your Lordship, page 29, Your Lordship. Page 29.
Just before that page.
I would like to read the content, Your Lordship.
Yes, page 29.
Page 29.
Yes.
Your Lordship, the sale deed is made and executed on Dimapur on this 14th March 2023. 14th March 2023. And the content is, Your Lordship, whereas the vendor is the actual and absolute owner with all rights, title, and interest of the vehicle Maruti Swift Desire registered DL2CAK 1214. Your Lordship, it is registered in Delhi, Your Lordship, and bearing chassis number so and so. On the next page, Your Lordship, on the next page, paragraph 6, Your Lordship. Paragraph 6. The vendor has handed over the RC of the said vehicle, registration certificate of the said vehicle with all other original documents related to the said vehicle to the vendee. Now RC, Your Lordship, registered certificate is handed to the petitioner on the execution of this sale deed. Now, why I'm referring this sale deed was executed on 14th March 2023. Now, when the investigating officer, Your Lordship, inquired before the RTO regarding this vehicle, the vehicle under whose name it has been registered, the RTO, Your Lordship, gave a reply, Your Lordship, to the CD, Your Lordship. Orange take, Your Lordship. Has been taken orange.
Yes.
Now, Your Lordship, it's written, reply to your application in respect to vehicle registration number DL2CAK 1214 Swift Desire. Sir, in response to your letter, I am providing information sought by you in respect of the following mentioned vehicle as per available in the Vahan portal. Name of the registration owner, Manoj Kumar. Date of registration is 21/12/2023, Your Lordship. Now my question here is, before obtaining before getting the RC, Your Lordship, how come the sale deed was, this execution was registered on, Your Lordship, if you can this sale deed again, Your Lordship. This was registered on 14, it was executed on 14 March 2023. Prior to the registration of the vehicle by the owner, Your Lordship, how can it be sold out, Your Lordship? RC was also handed over to the petitioner. Now, the question is, the discrepancies arising is here, Your Lordship. Now let the petitioner explain, Lordship. Before the RC is registered, Your Lord, before the vehicle is registered, how come this sale deed was executed, Your Lordship, and how come RC documents were given to the petitioner, Your Lordship? So let him satisfy that how come he become the owner? Let him satisfy before this honorable court how he is the owner, Your Lordship, how she is the owner, Your Lordship. Your Lordship, RC, it was registered on 21/12/2023, only on December, Your Lordship, 2023. The vehicle number was given, Your Lordship, in the name of Manoj Kumar Chaudhary. Now, this Manoj Kumar has executed and sold it with the petitioner, the present petitioner, and it was executed on 14 March 2023. How is it possible, Your Lordship? Now, let him explain, Your Lordship. If the court is satisfied, then I don't have anything because there are so many apex court rulings, Your Lordship. If the rightful owner comes, yes.
Yes, please explain.
But let him explain this position, Your Lordship. Then only, Your Lordship, let him establish.
The vehicle was registered on 21/12. RC was issued on 21/12 as per RTO's report.
Lordship.
But
And it's in the portal.
you purchased it in the month of March.
How is that?
Lordship,
So
I'm yet to peruse the documents which is finished before this honorable court, but that document which my learned friend has referred is regarding to renewal of the vehicle, Lordship. It is not a new vehicle, Lordship.
oh, yes. Where is the RC?
Lordship, if the
There is
RC is
no
not part of this petition, Lordship, but
No, you have the copy of RC. You
yes,
tell-
Lordship, I have the copy of
You
the RC.
produce the copy of RC.
Lordship.
Let us see the RC.
Yes, Lordship.
Tomorrow,
Monday, Lordship.
Monday or Tuesday, any day. Let him produce the RC. Keep the case.
Satisfy your lordship.
Because this may happen, might happen that because the vehicle is involved in NDPS offenses. So many things may happen.
Now, if we bring all this record, the petitioner in fact is
Because
coming
this
with unclean hands.
discrepancy is very major discrepancy. If you cannot overcome, your petition goes.
Lordship, I agree, Lordship. But have the, RC in original, Lordship.
Heard Mr. Muazzamir Lanet.
No, my submission is that, lordship, even if she brings the RC, if the RC is before the registration, your lordship, if the SLD is before the registration of the RC, your lordship.
I'll satisfy on Monday, Lordship.
Is that possible?
Let him bring the RC.
Lordship.
Lanet heard Mr. Muazzamir Lanet Khan. Oh. Call the stenographer. Item number 34. 23. Heard Mr. Muazzamir Lanet, counsel for the petitioner. Also heard Ms. Livika Lanet, public prosecutor, Nagaland. During the course of submissions, Lanet public prosecutor has pointed out that in the case diary, there is a report received by the investigating officer from Regional Transport Officer, Kohima, Nagaland, regarding the registration of the vehicle in question. And on perusal of the said report, it appears that the date of registration of the vehicle in question is 21/12/2023. However, she also submits that the sale deed on the basis of which the petitioner is claiming to have purchased, petitioner claims to have purchased the vehicle was executed on 14th March 2023. That is much before the date when the registration certificate was issued in respect of the said vehicle. Hence, he submits that the criminal petition filed by the petitioner should be rejected. On this, learned counsel for the petitioner prays for some time to allow the petitioner to file the copy of registration certificate, which is with her on the next date fixed. The prayer is allowed. Let this case be listed on when? Choose a date.
24th, Lordship, on Monday. I'll file in the first hour, Lordship. And if this matter may be taken up as fixed.
On 24th, 24/3/2025. The case diary which is available before this court shall be retained with the learned public prosecutor. You keep it with yourself, case diary.
Yes, Your Lordship.
Keep the case diary with yourself.
Obliged, Lord.
For admission from the supplementary course list, item number 34.
Yes, what is this?
May I please, Your Lordship? By this petition, I'm seeking your Lordship's kind indulgence in questioning an FIR as well as the connected criminal proceeding based on a compromise and settlement which has been arrived at between the petitioner as well as the complainants and the father of the victim.
What is the offense?
Now, the offense are section 323, 324 of the IPC and section 75 of the Juvenile Justice Act.
75.
75.
What is 75?
There will be cruelty
Sir.
to children. The
Special act is there.
juvenile justice.
Yes.
Yes, it is a, no doubt, admittedly, it is a special act, but in view of the settlement and compromise which has been entered between parties, I'm submitting before this court that neither the petitioner nor the complainant respondents, they are desiring of pursuing the criminal proceedings. So
Now, what is the stage of the proceeding?
charge sheet
Charge sheet has
has
been,
just recently
it is fixed at which stage?
for the examination of PW1.
Charges are framed.
Yes, charge has been framed under 324 of the IPC and 75 of the JJ Act. Sorry, 323. 323 of the IPC and
Juvenile justice.
I have a copy of the CC order if your lordship would like to peruse.
Yes.
The FIR is page 16 of the petition. And I have a type copy at page 17. Type copy is at page 17.
Yes.
This has been filed by the respondent number 2 and 3 on the authority given by the respondent number 4. Now, the offense was committed on 29th May 2024. The FIR was registered on 31st May 2024. However, on
Lima, ask the library. Okay. Yes, please.
FIR was registered on 31st May of 2024. If your lordship may come to page 24. On the 1st of June, the family members and the relatives of the petitioner wrote an application to the respondent number 2, who is the one of the complainant in this case, page 24. It was an appeal to withdraw the case. If I may be allowed to read this.
Actually, what was done with the victim?
Actually, the offense was, it happened on 29 May of 2024, where the victim child, the child victim, who was residing with the petitioner and her husband and family, education was provided by the petitioner's family to the victim child. At the same time, she would also help in the petitioner in the household chores. Now, it so happened that over the course of a certain period of time, her behavior became a bit unruly and disobedient. Now, on this evening, on 29th of May 2024, while the petitioner was feeding her baby, a toddler of 1 year old, she instructed the victim child to clean certain dishes, to wash certain dishes. However, the child was not listening to her. Now, this frustrated the petitioner. And after she finished feeding her toddler, she herself started cleaning the utensil. Now, of course, she was angry, and an impulsive act was committed on the victim child where she slapped her face with a scrubber. This led to certain bruises on the right cheek of the victim child. Now, on the next day, when the victim...
Where this detail is provided in the charge sheet?
It is in the charge sheet. Of course, I've also stated in my petition, but it is also in the charge sheet.
Okay.
Thereafter, when the victim child went to the school on the next day, the bruises appeared to be more prominent on her face. This was noticed by the school authorities who reported the matter to the CWC. Now, thereafter, the Pochuri Hoho, Kohima, now the parents of the victim child, they reside far off in Puchuri, somewhere in Puchuri. Now they authorized the Puchuri Hoho Kohima to take up the matter, based on which the Puchuri Hoho took cognizance of the matter and filed the FIR, based on which this FIR came into being. Now, subsequently,
And now this criminal petition has been filed jointly by whom?
yes, it's not a joint petition, but this has been filed by the petitioner based on the compromise and settlement arrived at with the complainants and as well as the victim's father.
Victim's father?
Yes.
How old is victim?
Victim.
Well,
11 years old at the time of the commission of the offense.
No, you said that this is a joint application.
No, it's not a joint application. It's the respondents, the victims, sorry, the two complainants as well as the victim's father, they have also filed a joint affidavit.
Oh, they have filed an affidavit.
Yes, joint affidavit, separate joint affidavit, stating to the effect that they are not interested in pursuing the case. And for the ends of justice, we are praying before this court that in view of the compromise that we have entered into, that allow us to live in peace and to continue with our lives. And we pray that this criminal proceeding that is pending currently before the GMFC Kohima may be quashed and set aside.
Now, what is your submission? Is there any bar?
No, I have certain authorities of this court also, and as well as the other courts, which has held that, yes, despite the presence of the Section 75 JJ Act, this offense is personal in nature. And if
you have authority,
yes, I have.
to...
No. I'm relying on three authorities. In sequence, I would first like to rely on the decision of the Kerala High Court. Now here,
which para?
Yes, paragraph 3, 4, 6, 7, and 8. Similar offense, Section 75 JJ Act, Section 324 IPC, and the court held that this offense involved it was personal in nature, and therefore it was deserving to be quashed to secure the ends of justice. The next case is a decision passed by the High Court of the Himachal Pradesh. Should I read out the relevant portions I'm relying on?
You have Lakshmi Narayan. Because these cases are relying on Narendra Singh and either Narendra Singh or
Narendra Singh I have.
Lakshmi Narayan. These three cases which you are relying,
yes,
the offense involved was under JJ Act.
Yes, all the three cases involve JJ Act. Now, even our High Court, passed by her lordship as she then was Kumari Pukan, she has also dealt with similar case involving Section 325 IPC and read with Section 75, 78, 82 of the JJ Act. And in similar circumstances, this court has held that in view of the compromise and the settlement that has been arrived at between the parties, continuation of the trial would be futile, as it would result in the abuse of the process of court.
Where is the compromise? Is there any agreement?
Yes, I have enclosed that in my petition.
Where is the page?
That will be at page
26.
26, yes, starting from 26.
What is your name? Vibino?
Vibino, Dr. Vibino Sabina.
And who is Rasang?
Rasang, he's the father of the victim child.
And who is appearing for Pochuri Hoho?
Yes, they are the complainants, represented by its president as well as the joint secretary.
Yes, what is the submission?
My lord, I'm for a respondent number 2 to 4. Respondent number 2 and 3 are the complainant, and respondent number 4 is the father of the victim. Now, my lord, as the matter has been amicably settled by the agreement dated 0809-2024, the family of the victim, the complainants, they no longer wishes to pursue the criminal case pending before the CJM Kohima. Therefore, we do not have any objection whatsoever if the criminal proceedings
Yes,
are passed.
Mr. Tibaphum.
May I please lordship, my lord, kindly allow me to refer the city.
Case diary.
Yes, ma'am. My lord, your lordship may kindly see page number 33. Charge sheet, yes, last. Page 33. Last third page. So my lord, I'm adopting the investigation report submitted by the IO, my lord. My lord, kindly allow me to read this paragraph. May I read, my lord?
Yes.
Upon investigation, it has been established beyond reasonable doubt that the accused had taken the advantage of the innocence of the victim child and had been constantly abusing her both physically and mentally. The child was brought on the pretext of giving her proper care, education, and job. However, it happened to be a nightmare for the child living with her foster mother, who was habitual in harassing and torturing her both physically and mentally. The inhuman act meted out to the minor victim by her foster mother has been proven by the injury caused by the accused on the instant case. The statement of the victim.
What injury was caused? Injury is of simple nature.
Yes, my lord.
Or is there any major
Simple,
injury?
simple. My lord, that hurt was caused in her cheek. Yes. And the child being at a tender age was not in a position to stand against the unfair treatment that she has been undergoing for more than a year. In light of the above mentioned facts and verbatim statement of victim, prosecution witness, and victim medical report, a prima facie case is found well established against the arrested accused. So, my lord, here, as per the investigation report, the case registered under 324, 324 and 323 IPC. 323 is non-compoundable, but 324 is non-compoundable. And my lord, and the 75 of JJX is non-compoundable. So, my lord, however, my lord, since the parties, they have settled the matter, has compromised the issue, so I leave it to your lordship, my lord.
But what is your submission?
Yes.
Should it be quashed, or should the petitioner number 1 face trial? Should the petitioner?
Lordship, the settlement and the compromise speaks for it. And
No. What is the state's
No,
stand?
my lord, since the matter has been already settled outside the court and the compromise has been executed between the parties, I'll leave it to your lordship, my lord.
No, ultimately everything will be
Yes.
left to me. I will have to decide. But what is your submission? Okay. Okay. Heard Mr. L. Iralu, learned counsel for the petitioner. Also heard Mr. E. Thibafon, learned public prosecutor, as well as Mr. A. Sophie, learned counsel for respondent number 2, 3, and 4. This criminal petition under section 482 or 528?
482.
482 of BNSS has been filed by the petitioner, Dr. Vibino Sabina, praying for quashing of the criminal proceeding. Criminal proceeding initiated.
Page 30.
In GR case number 93/2024, which is pending before the Court of Learned Chief Judicial Magistrate Kohima, Nagaland, arising out of Kohima Women PS case number 5/2024 under section 323 of IPC of Indian Penal Code, read with section 75 of Juvenile Justice, Care and Protection of Children Act 2015. The Learned Counsel for the petitioner has submitted that the that the petitioner and her husband have been providing the educational care and other care to the victim girl since 2023, and the victim is studying in government primary school Jotsoma, Kohima. Stop. It is submitted that Learned Counsel for the petitioner has also submitted that on 31/5/2024, the President and Secretary of Pochuri Hoho Kohima had lodged an FIR before the officer in charge of Women Police Station, Nagaland, Kohima, inter alia, alleging that the petitioner has subjected the victim, minor victim girl, to domestic violence, and it is also alleged that she was subjected to habitual harassment, habitual mental and harassment for over the years. Stop. Learned Counsel for the petitioner has submitted that. Where is your story that you lost temper in?
Yes, paragraph 5, page 5. Page 5, paragraph.
Learned Counsel for the petitioner has submitted that the incident involved in this case occurred on 29/5/2024, when the petitioner was feeding her baby and the victim started showing unruly behavior. And on this, out of anger, the petitioner slapped on the cheek of the victim girl while she was holding a stainless steel scrubber while washing the utensils. He submits that it was an impulsive act and it was an impulsive act of the petitioner, which the petitioner realized. And immediately first aid care was taken of the victim girl. Stop. Learned counsel for the petitioner has submitted that on that after completion of the investigation, the investigating officer of Women PS case number, what is the PS case number? 005/2024, laid the charge sheet against the petitioner under section 323/324 of the Indian Penal Code, read with section 75 of the JJ Act. However, the trial court by its order dated 26/2/2024 framed charges only under section 323 of the Indian Penal Code, read with section 75 of the JJ Act. Stop. Who are they in page 24? The father.
Yes, these are the family members and relatives of the petitioner.
Petitioner or victim?
The
Petitioner.
petitioner, yes. And thereafter, at page 25, a statement was issued by the complainant's party.
On learned counsel for the petitioner submits that on 1st of June 2024, the family members of the petitioners wrote a letter to the president of Pochuri Hoho, Kohima, praying for, requesting for withdrawing the case as the petitioner has undergone deep sense of regret and shame after the said incident. And stop. Learned counsel for the petitioner further submits that thereafter, on 8th of September 2024, a compromise deed was entered into between the petitioner, father of the victim girl, and the president of the Pochuri Hoho, Kohima, wherein the matter was amicably settled. And the victim's family informed that they do not intend to pursue the case any further. Victim family as well as the complainant had stated that they don't intend to pursue this case any further. Learned counsel for the petitioner has submitted that as the matter has been amicably settled between the, where is the victim staying now?
She's with her auntie.
Not with you.
No. She
Okay.
left.
Amicably settled. And as the incident occurred out of anger and impulse under the circumstances of the case, and the complainant and victim's family no longer intends to pursue the matter, it would be futile. It would be futile to proceed with the criminal prosecution against the present petitioner, as as there is an unlikelihood of the case ending in conviction. Learned Mr. Sophie, Sophie, learned counsel for the respondent number 2, 3, and 4 has also submitted that the said respondent do not have any objection if the before that Mita, during in the petitioner submissions, learned counsel for the petitioner has relied upon following rulings in support of his submissions. Narendra Singh and others versus State of Punjab and another 2014 6 SCC 466. Sahadevan versus State of Kerala reported in 2023 SCC online KER 414. Shakti Pathania versus State of Himachal Pradesh and another 2024 SCC online HP 1923. Father Matthew Puthumana and another versus State of Assam, criminal petition number 1308/2019, judgment and order dated 11/11/2019. उसके बाद learned counsel for respondent number 2, 3, and 4. Thereafter, Mr.
Has already submitted that the said respondent do not have any objection if the
if the criminal proceeding pending against the petitioner is quashed and relief prayed for by the petitioner is granted. On the other hand, Mr. E. Thibafom, learned public prosecutor, Nagaland, has produced the case diary, copy of the case diary of the case, and has submitted that there are incriminating evidence against the petitioner on record. And during investigation, sufficient materials were found against the petitioner. Is there any hope of conviction? Who are the listed witnesses?
Listed witnesses, they have not, here in the city, they have not enclosed, my lord. Witnesses have not been given.
However, he fairly submits that considering the settlement arrived at between the victim girl as well as the family members of the victim, complainant as well as the petitioner, he leaves the matter to the wisdom of this court. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. Though in this case the victim is a minor, and she suffered simple injury in the incident which occurred on, where is your petition?
29/5.
Which occurred on 29/5
2024.
2024. However, it appears that the incident happened on that day. As the petitioner, out of anger, slapped the victim girl. Stop. It is stop. As the matter has been amicably settled between the complainant, father of the victim girl, as well as the petitioner. Where is the and as the petitioner is also repentant about the incident. Stop. Incident, and there is an unlikelihood of this the criminal proceeding pending against the petitioner ending in conviction, this court is of considered opinion that it would be futile to proceed with the trial of GR case number 93 of 24 pending in the court of learned Chief Judicial Magistrate Kohima. Accordingly, this instant criminal petition is allowed, and the GR case, the proceeding of GR case number 93/2023 24 pending before the Court of Learned Chief Judicial Magistrate Kohima against the present petitioner is hereby quashed.
I'm deeply honest.
For admission from the supplementary cost list, item number 35.
Yes, what is this?
May I please, Your Lordship. In the main criminal case, there are two accused persons, accused 1 and accused 2. I am for accused 2, my lord. Before I open the file, I'll just, if Lordship permits me, I'll just give the clear picture orally so that, and thereafter I'll just take Lordship to the relevant annexures. I'll take only 10 minutes, my lord.
Okay.
Only 10 minutes.
Only 10.
Short, very short fact.
Okay.
My lord, what happened is this, my lord. The accused 2, who was the driver of a car, he, after arrest, he applied bail in the session court, but it was unsuccessful. Therefore, he has come before the reasonable court. Now,
Lima, just a minute. Keep this in the case of Mohan Jamil.
short one.
Yes.
The informant filed an FIR on 19 May 2024, stating that on 18 May 2024, the informant was driving the car where his father was seated in the car, Bolero. And both father and the son, they were driving around in Kohima town. At the same time, accused one and accused two was the driver. They were also driving in another car and also moving in town. In short, on the way, they have irritated each other by honking and blowing the horn, a vehicle horn. They have irritated each other somewhere. On reaching the point, a particular point called Pulbari or taxi parking, the informant and his father also stopped their vehicle on the road, middle of the road. Then accused one and two also, they stopped their car. So the father of the informant and accused one, they had a small altercation while stopping there in the middle of the road. Then out of that altercation, it is alleged that accused one had advanced towards informant's father. Then the altercation was intensified. As a result, the informant, the son, who was driving the car, also came out from the car and went into the picture scene. So in the process, according to, I'll show all the documents. According to the informant, the accused one punched the informant first.
Yes.
Seeing that the father rushed towards the son. So, and in the process, accused one punched the informant's father on his face. With one single punch, the informant's father fell down. That is on 18 May 2024. Thereafter, the informant's father, the victim was taken to hospital. Then from the hospital, the next day, he succumbed to the injury.
Okay.
Now, the short fact is this. After this FIR, if Lordship permit, just it will take hardly 10 minutes.
Yes, 10 minutes more.
My Lord.
10 minutes will remain constant.
Lordship may give some concession.
Yes, yes.
Then thereafter, my Lord, what happened? Case was registered. So on the basis of the FIR, the IO had recorded a statement of the informant. I'll show the statement of informant, my Lord. There before the police under 161, the informant had categorically stated that accused one had given a single punch to his father on his face. And as a result, he succumbed to injury, one. Then as a process, IO examining accused two, it's me, my client. Accused two was also examined. Informant was examined. Informant in his statement before the police categorically stated that accused one had given a single punch.
Okay.
Then accused one was also examined by the police and recorded his statement. Similar statement was given by accused one also. I'll show. Accused one said, admit, yes, I gave a single punch. And that's how the deceased fell on the ground.
Since when you are in jail?
It's going to be about a year.
Date?
On the first.
What is the date of your?
19 May 2024.
Whether charge sheet has been filed?
19th, yeah.
Charge sheet has been laid?
Yes.
Trial is going on?
Yes.
Trial is going on. What is the stage?
Evidence. Out of 39 witnesses.
How many have been?
2 have been examined. There are 37 witnesses. Now, my Lord, what is?
Now you come directly to the point.
Yeah, I'm coming to the point. That's what I'm saying. Even on merit, in my respectful submission, on merit, I have not done anything under section 304.
Why the trial court rejected your prayer?
My Lord, the sole ground of rejection is that if I'm released at this stage, I will hamper the investigation. I have a judgment on that. It cannot be on that ground.
You will hamper?
Hamper the investigation.
Investigation
No,
is
hamper the evidence, I'm sorry.
Okay.
Hamper the.
What is your age?
My age is
The mother is 20, 25. Where is the page? Judgment on the rejection order. That's why you should be always there. Now, my lord, short fact, that's what I'm saying.
Now 5 minutes. more.
Yes. So now the accused 2 was also examined by IO. Same thing, I did not punch at all. Then the best part is the fearless person is IO. The IO, after thorough investigation, in his finding, it is written, last part, conclusion. Charge. It is written in the page number 24. I'll hurriedly take lordship's attention to page now. Charge sheet. No, relevant part I have. Page 45. Conclusion, but the finding of the IO, where it is written charges established. That is starting on page 45. The relevant part, the finding. May I read what? Paragraph 4 and 5. May I read, my lord?
Yes.
The accused 2 persons used criminal force and assault the occupants of the bolero, deceased victim and his son. The accused person, accused 1, Nizo Setio Kire, assaulted the victim Tajavizo, the informant, by pushing him and trying to take him down. Thereafter, accused 1, Nizo Setio Kire, punched the victim Tajavizo on the face and subsequently punched the deceased victim, K. Lawrence Misal Hulu. 2, paragraph 5. After knocking the elderly victim down, accused 1, Niza Setio Kire, continued assaulting the victim Tajavizo while he was attending to his unconscious father. Where is my role, my lord? I may be tried for public nuisance, anything, but 304, far forbid. That number 1, my lord says, lordship wanted to see. Now I'll take lordship to the evidence that my lord will see. He appreciates it.
No, not
Yes.
necessary.
Then.
Now, Mr. Zimomi.
My lord, just 1 minute. Or just if lordship permits me.
Yes.
Now, lordship has asked the right question whether trial has started. Yes, started. Out of 39, the only eyewitness is the informant. He was already examined.
He has been examined.
There in his evidence, there is not an iota of evidence against me.
Where is the rejection?
I have a next, my lord.
No, where is the rejection order?
Lordship.
Whereby the
Page 47, my lord, bail rejection order. Lordship will see the relevant part, rejection, page 48, my lord. Last paragraph, page 48. May I read it?
Not full paragraph, only to those lines.
My lord. Then in that case, my lord, last page 48, fourth last sentence, my lord.
Yes.
Witnesses attending on the fact that this court is of the view that releasing the accused person at this stage on bail will lead to tempering of evidences of the prosecution witnesses who are yet to be examined. This is the only ground. This is the only ground.
Okay. Yes, Mr. Zimomi.
Lordship, I may be allowed to submit a citation. I have on all supporting all those.
No, if required, I'll ask.
Lordship.
No, there are
39 witnesses.
39 witnesses.
Lordship, on the next date fix, the PW 3 and 4 and 5, where the PW 3 is the son of the deceased, who is to be examined. And thereafter, witness number 4 and 5, who are the crucial eyewitness. Lordship, the incident, at the time when the incident happened, Lordship, the PW 4 and 5, who have seen the present accused creating nuisance, Lordship. And moreover, Lordship, which also resulted in
What has happened to
altercation.
the accused number 1? He's still in custody.
Lordship, he is still in custody, Lordship. And Lordship, a subsequent bail application was filed before the lower court below on 3 occasions, which was rejected. And thereafter, they
It's
approached.
me, it's me, it's me.
And thereafter, Lordship, they approached this honorable court by filing an bail application 17, which they have not annexed. Bail
Oh, that you have
applications-
not annexed.
That has
Lord-
not been annexed.
Lordship, what happened is this. Bail was rejected in trial court. Then we went to high court. Then high court passed only, I was allowed to withdraw, saying that you file a fresh bail application before the trial court. So we filed fresh bail application and we have come today. That much.
No, but you have to mention that you approached this court earlier also.
Lordship, which was numbered as bail application 17/2024. And the order was passed on 21st/10/2024, Lordship. So Lordship, this.
No, why you need his detention now? Because he may influence the witnesses. That is the,
Here, the Lordship is well aware and Lordship may appreciate, Lordship, here the offense committed by the accused is serious in nature, Lordship.
no,
And
but
moreover,
allegations are mainly against accused number 1.
Lordship, in fact, the allegation is also against the accused number 2, Lordship.
Where?
Since, Lordship, from the statement recorded under 161 CRPC, Lordship, if Lordship may kindly come to page 20, Lordship. Annexure C. Lordship.
Page 20.
Page 20, Annexure C of the bail petition. I will only read the relevant portion. Page 20. This is the statement recorded under 161 CRPC. And the third paragraph, Lordship, if I may allow to read. The relevant portion. On reaching Pulbari area, he accused number 2 show his middle finger to the traffic personnel at the traffic booth at Pulbari Junction. Upon reaching Pulbari bus stand area opposite to Oking Hospital, he accused number 2 parked his car swept on the left side of the road and came out of the car. Here, the bolero behind them also stopped, and after which they started shouting at each other. Meanwhile, they, accused number 1 and 2, went to the victim's vehicle bolero and his friend A1, so and so, pull open the front passenger bolero door, and the victim, so and so, step out of the vehicle angrily. As we continue verbal altercation with each other, the driver of the bolero, who was found to be the son of the victim, came out of the bolero from the other side, and on seeing them, the accused 1 and 2, here is stated that 1 and 2 shouted at his father. The son came towards them. Then his friend A1 pulled the son of the victim, and brief scuffle started between them. While we were involved in the scuffle, his friend A1 punched the son, so and so, first, and then immediately punched the victim, so and so, on the face, as a result of which the victim fell unconsciously on the road. When the victim fell down on the road and his son was looking at him, his friend slapped and punched the son, so and so, twice. Lord. So, Lordship, here the accused number 2 is the one who was driving the car, Lordship, the sweet vehicle. And he was the one who has stopped the vehicle, Lordship. And so from the 161, it has been clearly mentioned that he has showed his middle finger, which shows that he is also he is also involved. And then moreover, from this statement, it is found out that he is the one who has already instigated the issue, Lordship, and who has filmed the issue, Lordship.
Yes, Mr. Sophie, you are also appearing.
No, he is just assisting.
Okay, you are for? Wait. You have objections? No, you are only assisting the PP. What is your concern? That if he is released now?
Lordship, that will definitely hamper the trial.
Now, how?
Lordship, why? Because Lordship, since now the victim is no more lordship, and moreover lordship, victim as we is one of the senior citizen lordship and one of the prominent figure amongst the tribe lordship. He was also the PA to DC lordship at that relevant point of time lordship when this unfortunate incident happened lordship.
Okay, heard Mr. Azo, learned counsel for the petitioner. Also heard Mr. V. Zimumi, learned additional public prosecutor. You, sorry,
Public
sorry,
prosecutor.
learned public prosecutor Nagaland. This application under section 483 of BNSS has been filed by the
Mother of the accused too, my lord.
by Miss Nagun Yo Benio, who is the mother of the accused
Accused too, my lord.
accused too, namely
Kratzona,
Kretsonyu
Hure.
Vore,
Yes, my lord.
spelling यहाँ से देख लेना, हाँ? Who has been detained behind the bars since
19 May
19
2024.
5/2024 in connection with what is the PRC case?
My lord. Kohima North PS case number.
No, that is the police station case.
Yes. GR 83.
GR case number
83
83
of
slash
24.
2024 in connection with Kohima North PS
Yes.
case number 0045 slash 2024 under section 290 slash 352 slash 323 slash 34 slash 304 304
Redwood.
slash 34 of the Indian Penal Code. The gist of accusation in this case is that on where is the FIR?
My lord. Page 16, my lord. Page 16.
On 19/5/2024.
Type copy is page 17, my lord.
Teja Vizo B Mia Salho, spelling यहाँ से देखना page 17 से, had lodged an FIR before the officer in charge of North Police
Yes.
Station, Kohima, inter alia, alleging that there was an untoward incident on 18/5/2024 at Fulbari bus stand / taxi stand opposite Woking Hospital at around 4:40 p.m. in which the petitioner along with one who is the accused number one?
Accused Nizo Setyo Kire.
Petitioner along with Nizo Seto Kire was involved. It is also alleged in the FIR that the incident led to hospitalization of the father of the informant, who had to be admitted at the ICU at Woking Hospital. Stop. It is further stated in the FIR that the father of the informant succumbed to his injuries on 19/5/2024 at around 3:25 a.m. Stop. Mr. Azo, next paragraph, Mr. Azo, learned counsel for the petitioner, has submitted that the petitioner has been languishing behind the bars for last
10 months.
how
10
many-
months, 2 days now.
for last
10 months and 2 days.
10 months.
And 2 days.
How many days? 300?
10 months and 2 days.
10 for more than 10 months. However, till date, only 2 of the 39 listed prosecution witnesses have been examined.
Yes, madam.
Learned counsel for the petitioner also submits that in the charge sheet as well as in the statement of the witnesses recorded under section 161 of the Code of Criminal Procedure, the main allegation is leveled against the co-accused Nizo Setu
Setyo Kire.
Kire. And it was he who had assaulted the
Father of the informant.
father of the informant. Stop. Learned counsel for the petitioner has also submitted that in the meanwhile, the informant who has been examined,
Informant and his brother, both are brothers.
no, you stated,
Lordship, as far as the instruction that I received, now the PW3, who is the son of the victim, is yet to examine on the next day.
okay,
He has
And
five.
moreover, there's PW4 and 5, who is the crucial witness.
Who is
They have
the-
not been examined.
who is
We have
Teza?
seen the
who is Teza Vizo?
PW1, who was already examined, PW1.
now PW3 is the son of
Okay,
the
okay,
victim.
okay.
That
Oh,
that is yet to be.
Abhishek, last line.
And it was who had assaulted the father of the informant. The legal counsel for the petitioner has also submitted that in the meanwhile the
Informant Teza Vizo B. Mia Salho, who is,
PW1.
has already been examined
Yes.
as PW1. He also submits that in his deposition, the PW1 has implicated the co-accused of giving fatal blow to the
Victim.
that is the father of the,
Informant.
that is his father.
Yes.
Stop. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in trial. And as there are large number of witnesses in this case is unlikely to culminate soon, and hence he prays for allowing the petitioner to go on bail on any condition which
Yes,
may be imposed on him. On the other hand, Mr. V. Zimomi, learned learned public prosecutor,
Lord.
Nagaland, has vehemently opposed the grant of the bail to the present petitioner on the ground that though 3 witnesses, including the first informant, have been examined, however, some of the eyewitnesses
Lordship,
as well as the injured
who have seen the entire.
another son who was injured,
No, not the son. No,
only eyewitnesses.
witness.
Some of the eyewitnesses are yet to be examined.
And the son also. PW3 is the son of the victim.
He also submits that son of the deceased is also yet to be examined.
Lord.
And he submits that if at this stage the accused number 2 is released on bail, he may influence the witnesses and tamper with the evidence. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. Under what provision charges were framed?
Under section 352, 323, 325, 302, 334.
302 also.
No, no 304.
304.
When the
304.
charges were framed,
8/11/2024.
on perusal of the records, it appears that though the charges were framed against the petitioner and the co-accused on 8/11/2024, till date, only three of the,
Only two, my lord.
only
Two, like PW1, 2 only.
only two of the listed, only 2 out of 39
39.
listed prosecution witnesses have been examined. It also appears from record, no, on merit. It also appears from record that the main accusation of assaulting the father of the informant is on the co-accused Nizo
Seto Kire.
Seto Kire. And the role of the petitioner was of instigating the confrontation. Stop. This court is of considered opinion that as the informant has also already been examined and as the and also considering the nature of accusation against the present petitioner, as well as period of detention already undergone by the petitioner, that is within more than 10 months, his custodial, if he cooperates with in the trial, his custodial detention may not be necessary for fair completion of the trial in GR case number
84.
83
of 2024.
83 of 2024, pending before the Court of Learned
Trial session judge.
Learned Sessions,
Principal District Session Judge.
Principal Session Judge, Kohima. Kohima. The apprehension of the learned public prosecutor that the petitioner may abuse his liberty and may influence the witnesses while on bail may be addressed by imposing sufficient, imposing
conditions.
Imposing conditions on him while granting him bail. Stop. In view of above, the accused
two,
Mr. Kirets Sonyu Vuhori Mori is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned trial
Session
Judge Kohima.
Yes.
With following conditions: that the petitioner shall regularly appear before the trial court as and when so required by the trial court, and he shall cooperate in the trial. Stop. That the petitioner shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses or any other person so as to dissuade them from deposing before the trial court against him. Stop. With above observation, this bail application is disposed of.
Much obliged.
For orders, item number 27 and 28.
27 and 28 Somebody has mentioned. 20. Nobody has mentioned. These are last two. No, due to paucity of time, this matter could not be taken up today. Let this matter be listed in the next week on a date to be fixed by registry.